Hey everyone, sorry about the wait. There was a little bit of a delay after the hearing ended before starting this, but I appreciate everyone's patience. And yeah, we got Simon and Mary coming up here and usual crew. So yeah, for the people that missed the hearing, we'll be kind of doing what we always do, which is summarize. We get Simon's take on things, and anyone else that wants to come up and share their opinions, ask questions, of course, and then yeah, if people were listening to the hearing, I actually wasn't able to listen to the hearing today, so I'm really interested in everyone's takes on it and what I missed, basically. So yeah, Mary and Simon, how are you guys doing?
Doing good. I felt like it was a fairly quick hearing. And they went over on probably about 8 different topics.
So pretty streamlined hearing. There was quite a few things to go into, but they basically sounds like they were pretty quick with each of the topics.
Yeah, they talked about, let's see, the custody withdrawals and how that went. They gave some mining stats. They also went over co-counsel application, Selendi and Gay. I guess that's for the FTX and Westcap matter. The exclusivity extension, which was approved for 23 days. On the proposal disclosure statement, he went over that and how important that was. He wanted it to have an executive summary and be accurate and fair and be able to tell the story very easily. Then he went into clawbacks, and then he finished it off with avoidance preferences. I think that's about it, right, Simon?
Yeah. I think you covered the sequence of events. Um, would you like me to give a summary?
Absolutely.
Oh yeah, go yeah, Simon, let's hear
Okay.
it. Let's go for it.
So yeah, it was pretty streamlined. We're getting pretty efficient at these things now. So a few things to point out. So it started with Chris Ferraro, and I've just pinned to the top of the nest my notes from the live broadcast. They last night he gave or they published a presentation, and really this was just about giving an update on custody, letting people know that a big chunk of those KYC has been performed. So, we're putting the people we're paying for to work to do something, and really a show for the regulators, showing that they had blocked certain transactions because they didn't meet the correct KYC requirements or PEP and sanction. Just really trying to show that there is a robust process for processing these withdrawals. To me, this is a pretty positive sign that these custody withdrawals have actually been returned, proving that when the time is right to release earn, um, you know, even if we were involved in some kind of controlled liquidation, as opposed to getting through the reorg, the Celsius, the app can actually be used for that. And so, if regulators are allowing them to um, send these funds without causing an objection, so I think that was really the purpose of this slide. The second part was going through, yeah, more on KYC and stuff like that. And then they did an update on the mining. The it's I so badly just want to see a clear financial model, but I think the reason we're not getting one is because they had to restructure the whole thing, and it was so badly commingled with in how it was set up. But at this stage, the mining operation should hopefully be a standalone organization rather than the craziness of how it was before. But we still just don't have just a clear, cash flow, income statement, balance sheet, to really understand the assumptions behind how they're calculating EBITDA, how they're doing the depreciation calculations, what the actual agreements are. But we know that apparently we have approximately 120,000 miners, and they had to take 17,000 of them out of Core Scientific as part of the Core Scientific bankruptcy. And beside the point, this wasn't covered in the hearing. We still need to, Celsius still has those illiquid assets, the convertible note for Core Scientific, which could actually, they put 54 million of our money into Core Scientific, and that could end up as a decently equity holding or debt structuring after the whole their Chapter 11. But they said that after the 17K mining rigs they had to take out, they've managed to get 7K of them back online. They're mining approximately 9 to 10 Bitcoins a day. And they gave some promising charts of how they're getting to a 40% margin. But, I want to take those for what it is, but I also just want to see straightforward numbers. For some reason, we still don't get to see those, which I think is just really, really important at this stage, to be able to see how the mining operation, because it is so crucial to our recovery. And yet we still can't answer just basic questions. But they gave an overview, they gave some charts on that. That was the first section with Chris. Then that's the usual well-rehearsed Kirkland and Ellis telling Chris what to read from the script, in the usual way. Then it moved into some White and Case conflicts. Squeezers were like this one. There was a bunch of stuff on White and Case representing in some people in the FTX case, some creditors in the Westcat DD. So they were getting approval, I think, for getting alternative counsel where conflicts exist. I'm sure there'll be lots of conspiracy theories on that part. Just going through my notes as I'm doing this. Then it went into the extension motion. So that's the extension for approximately, I think it's 23 days till the 31st of March. And also the extension of the bidding timetable. We got when I spoke to Ross at Kirkland, when I was dealing with other matters, he confirmed that the stalking horse was put in there so that we can open up a competitive process as a result of our efforts. So things are working. That's great to see. So we got the stalking horse bids. We've got a competitive market. Kirkland were presenting and UCC were presenting, and everyone was sharing how there has been genuine progress towards the plan. There was a bit of a slip where they said, it was almost like they only started working on the plan just before when we all started applying pressure, when the UC said there'll be no extension deadline unless you submit, and we break up on Valentine's Day. They kind of, I noticed carefully the wording that they used. They kind of only really started working on things around then, when they, but, in terms of a concrete plan to put together. So that came in. But also I really, in hindsight, or in the future, I'd love to know when Nova Wolf started to come into the equation. Whether they were predestined to win this all along, or when that actually came along. I think that would be really interesting. But anyway, they're going to get the extension, so that was granted. No surprise there. So they've got an extension to the 31st for Celsius to have exclusivity. That gives them the time to progress on a disclosure statement. The judge was asking them to have a clear executive summary that's just simple when they start to get to the disclosure statement. And then they also said that they will be open to competitive bids, and that will continue. I think the deadline is 17th of April for the competitive bidding process to come through. They confirmed that they are speaking with one other party, but nothing that's close to the level of work that they've been doing with Nova Wolf in terms of putting together a term sheet, which obviously they put a lot of time into that. Just looking at my notes again, give me a second. No objection from the US trustee. Then I think we had our usual objections.
Simon,
Yeah.
Simon, if I can, you said no objection to the U.S. trustee. So I think that wasn't she worried about liquidity
right.
though? She was worried about that
Yeah,
part.
thanks for pointing that out. So she said that, she's not going to object for now, but they are speaking in good faith. But she mentioned the liquidity concern with regards to, yeah, I don't know how they're going to solve that one, but that's an interesting one. What else have I got here? Choo. Then I've got in my notes, yeah, you get your user objections from, I don't know if Manny and David Fishberger here. David, is it? What am I saying? So I was looking at David Adler's notes as well.
I think you were trying. Sorry about that. I think you were trying to say that they withdrew their objections, both of them, I believe.
Yeah, they withdrew their objections, just stating that they would like alternative plans to be published. But yeah. Then David Adler came up. David Adler said that they are working on negotiations, but no agreement has been reached. They want to know whether the plan applies to non-US. And my guess is that Figure doesn't have any licenses outside the US. And many crypto businesses kind of regulate themselves in one country. And then, like at Bank to the Future, we spent years going into every country's regulations and building a custom onboarding process. But in general, US companies tend to comply with their own country and then just assume that they're compliant everywhere else. But this may, given the number of people that will have complaints here, you may get international regulators. So they were talking specifically about some borrowers in the ad hoc group. I think they mentioned Australia and Switzerland and Spain to demonstrate their compliance in order to service the borrowers. I don't know how they're going to get an answer from that, but that will be interesting. I don't know if David's coming on today.
David actually filed an adversary action right after the hearing closed.
Oh, okay.
On behalf of the loans group.
Cool. We can go into that. I haven't seen that one yet. What else have we got here? Then, yeah, as Mary said, I think Judge Glenn took it upon himself to talk about clawbacks. I'm assuming he's been bombarded by emails and concerns from people that are concerned about clawbacks. But he talked about, I think YOLO put a good tweet kind of summarizing it. Maybe YOLO wants to go into this part, but he was saying that it's their he complies with the law. I think he was saying he'll follow the law, and this is something that they have to, and they're focused on fairness, and they don't think it's fair that some people would have withdrawn and others would have got the full brunt. So that's going to be a big thing there. But then he also said there are valid defenses, and when people are ready for those defenses, he'll listen to them. Yeah, is that accurate, Yolo?
Yeah, I mean, basically, yes. I mean, he said clawbacks, are part of the bankruptcy code. I'm going to follow the code, and when it's time to rule on them and the validity of the defenses, then I'll deal with it. But I'm not going to do anything until then.
Yeah. Because just to quickly comment on that, I don't know what your guys' thoughts are, but I would say that a lot of people took it as like the judge is 100% pro clawback or something. Like that's what I didn't actually listen to the hearing, but yeah, there are some people freaking out saying, it's already a done case, like from, obviously emotionally reacting, but I guess you summarized it already, YOLO, but the judge was just it sounds like the judge was just kind of laying out like, this is why it exists in the bankruptcy code, and then basically said he's going to follow the law, right? Depending on the defenses and what's put forward, right? Is that how would you describe it?
Yeah, I remember him saying that it was an important part of the law, and he wanted to provide, equitability to the creditors. That's what he said, right?
Yeah, and I mean, I think Judge Glenn has been very much kind of by the book, right? And when there's questions of law, he'll rule on them, but he's not going to rule on them until the proper time and they're properly framed for him to rule on.
Right. Okay. Yeah. No, thanks for clarifying. We got David here as well now, which is good. Thanks, David. Thanks for coming up. How's your day?
It's been pretty busy. I just tuned in and heard the tail end of the discussion, and I think my own impression was that you know, the judge is aware of the fact that people are quite upset about preferences, and obviously, uh, probably heard about the BitBoy stuff. And I think he just wanted to say that, there's a principle under bankruptcy law of equality of distribution, uh, and that provides for a 90-day look back window. And, it's something that's there, and don't blame the estate fiduciaries, for bringing it up. But if it does come up, I'll rule on it quickly and in the most efficient way possible. I didn't take that, and I saw some of the tweets about, the judge being pro preference. I didn't take it that way. I just thought that it was sort of a response to what's going on in Twitter, and just trying to explain that the reason for the purpose for the law, and the fact that it's not the fault of the estate fiduciaries, the committee and the debtors. It exists, and he said several times, there are defenses there. I think he said many defenses that could be raised, and if brought to him, he'll rule on them expeditiously. So I thought it was a neutral, frankly, description of the situation. I mean, I think it would be. I mean, I wouldn't expect that the court would say, I've heard about these preference claims, and I just think they're crazy to be brought. Obviously, the judge isn't going to do that. Without having the issue briefed in front of him. So that's my take on it. It sounds a lot like what I heard from the tail end of Crypto YOLO.
Yeah. Well, I really appreciate Yolo and David, you guys sharing your perspective, because it's a language, right? Like, you listen to these court hearings as a layperson, you don't really know. It's hard to read into the nuance and read between the lines and understand, what's normal, what's not normal, and how judges speak and how lawyers speak. So yeah, that adds some clarity to the situation. I mean, I'd have to dig into this more deeply to understand 100% on this topic, but I'm pretty sure that Judge Glenn has ruled in favor of clawbacks or preferences at times, and in other cases he's ruled against them. So I think his track record is for and against. So you can't say that just based on a few lines in a hearing, this judge is pro clawback, therefore clawbacks are inevitable. No, he's just framing the situation so that people understand that are all there's a lot of lay people tuning into these hearings. So he's trying to get everyone up to speed on how things work. And ultimately, he'll just follow the law, and he'll look at the strength of the defenses and how they're brought, and that just requires litigations most likely. So yeah, he's ruled in both directions. So I think at this point it's just an unknown, but we shouldn't really jump to conclusions.
Right.
I know a lot
and
of
I would say also consider the context in which it was said, which is it was really in connection with exclusivity. So there are a lot of people, right, who are rightfully upset right now that they might be subject to clawback, and there are people who don't understand it, and I take it as sort of the court explaining to people that this is this exists. It exists for this purpose of equality of distribution, and saying it in the context of exclusivity, you know uh, as a comment to sort of calm people down, and or to say that it's not the estate fiduciaries who are making this up. This law exists, and it just it can't be ignored. I mean, I think the committee put in a document a couple of weeks ago that said that put some stats on what the potential preferences are in this case, and it was a number, my recollection is between 3 and 4 billion. So that's the way I took it, and I kind of knew that the people out in Twitter were going to interpret it as sort of position one way or the other on preferences, but I didn't take it in that way.
Okay, awesome. Thank you. We can, yeah, you guys want to move on to
also on the insider clawbacks part, so White and Case kind of gave their pitch for the litigation trust, and it was very interesting seeing Kirkland talking about ordinarily they would be, trying to defend quite aggressively, but they were very much distancing from this isn't Celsius 2.0. There's no management. This is a bid reorg. There's going to be no more Celsius, and we believe that creditors deserve, all of those rights to sue Mazinski and everyone else and everything that was covered in there. So, they were really, Kirkland was really trying to express that they're on our side with that part, and that they're not really playing their normal role of defending the estate, because they really see this as the bid reorg is moving over to Nova Wharf. Then there'll be a litigation trust, and they want and believe that creditors deserve the right to sue Mashinsky and all the insiders.
Yeah, to that point, in contrast, like the Voyager situation, I know we're going to stick to Celsius here, but the Voyager situation, just to contrast it, there was a plan that was being proposed or voted on or whatever, and one of the things was actually like releasing the C-suite from basically everything, like all liability. There was some crazy thing that was trying to be pushed through, and then there was, objections to that or whatever. But we're not seeing that with Celsius. We're not seeing like them trying to push forward a plan that releases all these insiders and all these C-suite from any kind of liability, because I think there would be just absolute outrage if that was the case. So it's nice to see that it's going the direction it's going, and that we're going to.
I
going
just
the
add to
opposite.
that.
Oh, really?
In Voyager, and sorry for piping in, but the one thing that I found very interesting in Voyager is the judge actually did release or exculpated everyone from any potential liability relating to 1145, which relates to exemptions from registration of securities, and that was all based on what was going on with the SEC, and the SEC not saying that we think there may be an unregistered security here, but refusing to sort of back it up or follow through with it with any of their own rulings. So when the issue came before the court on the scope of the releases, my understanding is that the judge said, well, if the SEC can't decide whether this is a security or not, I'm not subjecting the parties that are involved in this, the debtor, the plan sponsor, to potential securities violations when the SEC hasn't even made up its mind yet.
Okay, I'm behind on the times then. I want to hear what Yola has to say.
Yeah, so I think that's what happened just at the last day on the plan confirmation hearing. But I believe, and I'm not a Voyager expert at all, I haven't been nearly as involved, but there was essentially a settlement with the C-suite where the CEO and the CFO, I believe, paid a couple $1 million or something back, and that's how they settled out claims with the CEO.
Yeah, it was 1.2 million. Yeah.
Right. Okay, I thought it was over 2 million on the CEO, on Steve.
Okay, maybe.
But in Celsius, kind of the exact opposites happened, right? Which is that it's been made very clear that claims are being preserved against the directors and officers, and that they're going to be pursued, by the litigation trust. And you have a draft complaint already that was filed by the UCC that's going to go over to the litigation trust. But I think that the technical point in today's hearing, which David can probably provide the accurate insight on, is that there's kind of a split in the D&O policy. So that the D&O policy, for the most part, is being given, to the litigation trust to pursue claims on it. However, there's a piece of the D&O policy that's going to be left on the debtor's side, the old co-Celsian side, to the extent that the executives and directors and officers actually can make their claims against that D&O policy to fund their defenses. Did I get that right, David?
I believe that's accurate. I looked at it, and that was my interpretation as well, but I have to say I didn't study it for any great length of time. I mean, I thought that your interpretation is consistent with the way I read it as well.
And do we know yet how big that D&O policy is?
No, I asked back in November. I was told someone would get back to me. I'm still waiting.
Okay, and then I'm hoping.
And by the way, even if it is, $100 million, what I've learned is that oftentimes these policies have an exclusion for
fraud, yeah.
actions related to cryptocurrency. So I haven't
Oh,
seen the
really?
policy. Yeah. I mean, I've learned that from some of the other
Every
crypto
insurance
cases.
claim, every insurance claim. The very first one that I was involved in was BitPay, when there was a hack, and then every single insurance claim I've ever seen with any crypto company, the insurance has found a way of getting out of it.
Yeah.
Well, so David, the other thing is just before you leave, I'm hoping that you'll comment on your adversary action that you filed for declaratory judgment on behalf of loans.
It's there. I think that that it covers the bases for. I mean, the items that are included are, property of the estate. The fact that the loans are all consumer credit transactions under TILA, which, provides certain protections under 363.0. Fraudulent inducement. I believe there's a consumer fraud claim there, and basically, a request for a declaration that the loans issued against the collateral are not enforceable because of the failure to because of fraudulent inducement and because of the failure to issue to obtain proper licenses. I mean, this sort of comes down to a state by state analysis in some ways, depending on choice of law. But I'll give you an example. In both Arizona and California, there are statutes that say if you're issuing loans to someone in this state, you need a license. And both of those states have a provision of what the effect of not having a license is. And they say that, a loan that's been issued by a party that doesn't have a license is void and unenforceable. So, if assuming the matter is not resolved and it goes forward, I mean, it's going to be, and I think Judge Glenn referenced this at one point, that, there's going to be it's going to be extremely complicated because it's going to involve interpretation of different state consumer fraud laws, different states and international, laws regarding lending, et cetera, and what the effect is for not, being in compliant with state law or federal law or international law.
Yeah, David, on that one, I mean, I can just share a bit of my experience. So when we were doing peer-to-peer lending in the UK, I invested in several companies. The UK take that really seriously. If you have to be registered with the FCA,
Yep.
With a consumer credit license, and there's all sorts of regulations. So, I mean, the fact that Celsius was issuing these loans globally, you can't take, you can't necessarily take the approach of comply in the US and then you comply globally. So you've got the international regulators to be considered in these negotiations, and Figure to me is a US first business. It looks like.
Right. I think that's a great point, Simon. And, if you think about Celsius in the UK, what they did, because of my understanding is because of their concern, is, they basically engaged in a lending practice by calling it something else called a repo. And there are all the repo transactions that were done in this case, and you can find the form of agreement. I guess there were several versions of it. I think that's attached as Exhibit C to the document that they filed with all the terms of use, and that's 393. But um, my understanding is that the reason why they went to this repo structure was to avoid tripping over those UK laws on not having valid licenses. And the repo people in this case have been the UK people have been pretty quiet. I haven't really heard from any of them during the course of the case, but I mean the repo book is not insubstantial amount of claimants out there. Let me put it that way, from what I can tell.
Hey, Plan C, do you mind if I jump in and ask a couple questions real quick?
Oh yeah, go for it. Yeah.
Cool. Hey everyone. So 2 questions. I'll ask them quick, and then you guys can all opine and jump in. The first, I guess, is to both, I guess, Simon and David. Do you guys? They listed, I think, like 15 or less insiders on their report. I mean, Celsius, I think at one point had over 500 plus employees, or at least over 300 plus employees. Do you think that list is going to grow, or why haven't they included more employees on it? I mean, just Zach just comes to mind, just off the top, right? And there's definitely other employees there that I would assume knew about what was going on. I'm making assumptions. Clearly, I didn't work there, so I have no idea. So I'm just confused as to why they only limited to the 15.
Is it 15? I thought it was only 8 so far.
Well, that's what I'm saying. Less than 15. Like I don't even. Yeah, right. Plan C. Exactly. Even more shocking, right? So that's my first question, and then the second question kind of relates, David, to what you said about what Judge Glenn said about regarding clawbacks, about, I guess, equality for all. Clearly, there's different classes, right? There's earn, there's custody, there's withhold, there's loans, and God knows how many other classes there are. Everyone feels that they're situated somewhat differently. So when he's talking about equality for all or fair distribution, again, I don't know what terms he used in court today. Do you think that he was suggesting that each class would be treated the same, or that everyone would be treated the same? Hopefully that makes sense. Meaning, if it's a 100,000 threshold, it's for everyone, not for XYZ class or this class, or if it's or even international is situated differently, right? It's like $1 million for international, but earn, it's like 250 or 100 or whatever. Do you feel like he was? Am I making?
Yeah, no, you're making sense. I think
okay.
that he. I mean, there a plan will set up classes of creditors, right? And there'll be a treatment afforded to each class. And I think what he was referencing when he was talking about equality of distribution is the fact that some people were able to, withdraw everything, and under the principle of equality of distribution, you know, some classes are going to take a very large haircut, and that the bankruptcy code has a mechanism that's in 547 to sort of equalize those who managed to get out early versus those who stayed in. And I think the reference is clearly that the benefits would be shared with the creditors who are suffering right now, i.e. the creditors of the estate, not those who were able to pull out. It's not as clean as that, because there are a lot of people who have money on the platform still and took out, right? So that creates all sorts of issues. But I think he wasn't referring necessarily to any particular class. He was just referring to those people who are creditors now versus those who managed to get their crypto off the platform before the pause. So that's the way I interpreted it. As to your first question, one of the issues. Listen, I haven't been too shy about expressing my opinion about clawbacks, but one of the things that I think is a problem in this case is there are people who got preferences situated all over the world, right? In the US, Canada, Europe, Australia, Asia, and just the laws of those countries alone, sort of depending on the country, make it easier to recover from US based depositors rather than depositors in China or in Germany. So that's sort of an inherent unfairness in sort of the preference provisions, because they will be easy to enforce against people who live in the U.S. They will not be easy to enforce against foreign residents. I had a case a decade ago where I had to serve some people in mainland China, and to essentially get a complaint served, you had to go through the People's Ministry of Justice, and where they would translate it and then they would serve it. I'm sure that the People's Ministry of Justice is not going to be very willing to serve complaints that are filed in a bankruptcy court, in New York City. So I mean, there's sort of an inherent unfairness um, in that sense, because I think the burden falls more on recovery on creditors who live in jurisdictions that recognize U.S. law.
But wouldn't that go against kind of what the judge was hinting at, which was like equality for all? If you're favoring international over, and I hate to use that term,
Yes.
right? Okay, so then going back to, I guess, my main question here is, that would mean that the judge is probably already in his mind the classes will be treated differently, but everyone in the same class would be treated the same. That
Yes,
okay,
absolutely.
okay,
Yeah.
all right, that's all right. And then I guess my first question was in regard to like the insider. Anyone here can
Yeah.
opine. Like, why do we think that there hasn't been
I,
more?
I I think that it was just a complaint, a massive complaint that was put together by the committee, identifying the wrongdoers, the principal wrongdoers. I mean, there are probably a lot more insiders out there um, than were listed on the complaint.
Right.
Simply people who had knowledge of Celsius's financial condition. People who had knowledge otherwise, but that knowledge, those people are probably um, limited. The actions against those people would probably be limited to, either fraudulent conveyances or preferences, and would not fall into the bucket of all the other claims that were asserted, in the complaint that the committee prepared. But I don't think you should take it the fact that there are 8 people who are identified as insiders, in that draft complaint are the total sum of insiders in the case.
Yeah,
Well,
I think that there is, an issue that there is a difference between directors and officers and rank and file employees in terms of the level of responsibility for the fraudulent actions and malfeasance that took place beforehand. Because rank and file employees actually are under the control of the directors and officers of the company, so they're the ones that really bear the responsibility for for the bad actions. Their individual actions, as David said, that they may have done for personal gain in terms of taking money off because they knew inside information. That's a different issue. But in terms of bearing responsibility, it really falls to the directors and officers of the corporation.
one of the things that I'm sure many of us can agree upon, at least the vast majority of the community, is that some of these insiders, in my opinion, probably the vast majority's opinions, are still pushing this 81-cent cell token narrative. And these are some of the insiders that were part of, not everyone, obviously, but a lot of those hardcore 81-cent cell pushers were probably at least insiders with cell, and they're still out there pushing this narrative. And until their name is like in some sort of court document telling them basically they're on the watch list and to shut the fuck up, they're going to keep going at it, right? And it's driving me nuts.
I think in bankruptcy, everybody's an economic actor. And so people that
Right.
have large sell bags are pushing 81, whether they're insiders or outsiders, doesn't matter.
Mhm.
If they've got large sell bags on the platform, they're pushing it. Now, it is true that a lot of employees got paid in sell or were
Right.
encouraged to take loans against sell and things like that, so that they're, in terms of a proportion of people that are sell bag holders that are employees or ex-employees versus non, compared to the general creditor community who aren't sell bag holders, that disproportionateness exists. But I think everybody's just being an economic actor, honestly. And I think that there's legitimate arguments for cell 81. I was thinking about this today during the hearing. I think there's better legitimate arguments for both cell 81 0 and sell in kind than I do think that there's a legitimate argument for cell 20, which to me seems highly arbitrary.
Yeah,
Agreed.
really quick.
Thanks.
Oh, go ahead.
No,
Are you done now?
sorry. No, sorry. I was going to say thanks. I appreciate it, Clancy, and Mary. Thanks, and Simon and David. Thanks.
No, thanks, Eric. Thanks for coming up. And yeah, just one quick comment. Like, Yeah, I completely understand people within the creditor body having, being upset with specific individuals for whatever reasons. But just understand that we don't want to blanket, a whole group of people based on certain people's actions you might really not like, right? So I've talked to lots of people that are large cell token holders. They basically haven't really been talking. They hold a lot of cell, but they're not the kinds of people that you might see on Twitter. They're more behind the scenes. They're just regular Joe investors. They got screwed essentially like everyone else in this process. So yeah, there's a lot of people that are not speaking, and of course the people that are the most vocal, they end up kind of being the face of a whole bunch of people. So just don't lump everyone in the same basket and don't blanket a whole group of people. There's varying degrees of individuals with all this stuff.
I
So
agree with Plan C. I think that was a very good way to say it. I mean, you can think of an outsider who just purchased Cell, towards the end. I mean, that person was sort of left holding the bag, and may have thought at the time that, Cell was a good investment and had no idea, was not associated in any way with the company or or had any connections whatsoever. And you can sort of understand the argument that they're the ones who might have purchased Cell for $3-4 or whatever the hell it was, at a certain point of time, and the person who actually sold it to them benefited. So I mean, I think there are two sides of the coin. I agree with what you say, Plan C.
Yeah, I originally gave 81 in my original plan when I released the video on how I think it should be done with the equitable haircut strategy. And the reason for it was not for any other reason than I thought there'd be huge regulatory issues with Cell Token, and so therefore it is going to become an issue. Now the Voyager case has set an interesting precedent, but there's so many differences between the VGX token and the Cell token. I mean, it didn't have this big examination manipulation case. The VGX token, from my understanding, having spoken to Shingle and the people that created it, is it was acquired, it was distributed, there was no ICO, it wasn't used as a mechanism for raising finance, it wasn't used in order to manipulate the price and many of the things that came out in the examiner report. It wasn't registered as a security like the Cell token. So there's many differences that and this was just the only reason I feel like people in the community turned on me really early, because I just tried to point out these facts that it took 8 months until they came out. But the reason I gave 81 was simply because I thought it removes a regulatory issue. And I saw so many people that I thought were genuine victims of Mashinsky's manipulation, and there are a lot of people that are victims of that. That's very different to the characters that we've become used to. So unfortunately, the people that in a sense, I mean, they're doing a bit of a disservice to the genuine victims, because people like Eric are coming up and saying, "Screw you all, I hate you," and all this stuff because of just the way. But there's so many people that are just quiet in the background where this is really devastating to them, and if you listen to them, you can see their case of why they were genuinely manipulated into this, and they were just victims like everyone else. But unfortunately, the way that this has all turned out is the people that are still to this day defending Majinsky and kind of creating all the conspiracy theories that and holding on to thoughts of the past have kind of been connected with that thing. So it's an unfortunate thing, but it should sort itself out, and I still stand by. I think that is the best way to deal with it.
What if they just paid out all Cell token holders in just pure equity?
Yeah, I think Cam came up with an interesting strategy of how to distinguish, because just so you know, all accounts and all balances, they're marked whether they're insiders or not in the data. And so everyone knows who the insiders are, and everyone knows the data on on what the entry price was. It's a bit of an exercise. So Cam came up with a strategy of trying to make sure that those that were more victimized, a higher percentage from those that were part of or for example paid for free. And the even if you just give equity, tone is still the same thing, because you've got to determine the ratio of the equity that they're getting based upon the price at the petition date. So you still got to face the pricing issue. But then if you give coins or give equity, is you still got to face the pricing issue.
No, but if you just give them 81 cents, they're not going to get the distribution, like the 30% or whatever in tokens, and then they just get that whole 81 cents worth in equity.
Yeah, I mean, that's a viable idea, right, Tony? It's just a question of it's not Cell 81's plan, it's not our plan, it's the debtor's plan sponsored by Nova Wolf, and so it's whatever the debtor and Nova Wolf wants to propose or negotiate in the plan or in some sort of settlement agreement that it gets it worked out. And I think that the Cell 81 guys, what they're really trying to do is get a seat at the table so that they actually are involved in the negotiations, as opposed to just leaving it to Nova Wolf and the UCC and the debtor.
Yeah, I don't know if they're smart enough to think that far ahead, but in this scenario, it's basically just everyone gets what they don't like. Like the people that are very much not in favor, like Eric, are going to be upset that they got the 81, and the people that want 81 or more are going to be like, well, I wanted some cash as well. So everyone's going to be equally unhappy, basically, which is the whole point of bankruptcy, from what I've understood.
That's the whole point of any litigious process, right? Is that everybody gets equally unhappy with a settlement, and that means it's a good settlement.
Yeah, the one thing I would say though, guys, is like as of like 3-4 weeks ago, Cell was just like any other earn user, right? So all of a sudden it's considered this separate class. Now we don't know legally if that's even possible. So I think there's a lot of unknowns to that. I don't want to go into a deep Cell token discussion. Most people don't care. Most people aren't here for Cell. So I totally get that. So yeah, we'll see what happens with Cell token. I mean, yeah, there's a lot of possible outcomes for Cell, and I just don't think the majority of people on this call even care. So yeah, anyways.
If we're gonna pivot, if I can go back, because I got a couple of DMs about this. When the U.S. trustee was worried about liquidity of the plan, I guess someone wanted. I have two people that asked me to explain that a little bit because they didn't understand that. If whoever could answer that, and then if whoever answers it, then Tecmo, you can go right after it.
I'll answer it, but it was more of a passing comment. So what I say may not be what they were thinking. But if it is what I'm thinking, then they probably were thinking about the liquidity of people's ability to exit their equity, because at Bank to the Future, when you invest in a company, you're tied together for 7 to 10 years.
I'm sorry, Simon, that wasn't it at all.
Oh, right. Okay.
The liquidity issue that they raised was essentially that the company would have sufficient liquidity to operate through confirmation of the plan and its effective date, so that it could basically support itself until that time when recovery could be obtained by their creditors.
Okay, that makes a lot more sense. Yeah, because they did do a timeline and it was tight. They said that their cash flow, Judge Glenn made a comment that they've got sufficient liquidity, but it is creditors' money, and round about that June-July time, which is when they think they'll have all the votes and ready to go, is also a key time when they run out of liquidity. Yeah, that makes a lot more sense. Yeah.
Okay, thank you. Go ahead, Tecmo.
Yeah, just wanted to make a couple quick points. You can hear me, right?
Yes.
Okay. Yeah, so I think the Cell token solution, real quick, is just once you take out, if you zero out insider and manipulator claims for Cell, the remaining is really not that much, and it will have minimal effect on the rest of the process, I think. So if you do that, then you can give them 81 cents of EST, and it's not gonna sway things too much. So I think way too much is being said about something that is very, very minor in the grand scheme of things. Um, and then other than that, when we talk about regulatory issues, we talk about, securities, we talk about liquidity of ongoing. You know what doesn't have any of those issues? Liquidation. So if you actually go through with liquidation, you don't have to worry about what Simon went through with 100 different countries, with Bank to the Future, with this, that, all these other issues. You go through with some sort of Chapter 11 liquidation. Everyone gets some percentage of their assets back. They don't want EST tokens. They don't want MST tokens. Like, this is the overwhelming consensus from what I've heard, and it gets talked about as if it's not really a thing. And that's what blows my mind. Like, people don't want Nova Wolf. They don't want it. So why is this that like that's what blows my mind. Like, people don't want venture capitalism with their life savings. It's as simple as that. There are some people who do view this as YOLO degen venture capitalist money, and that's fine. If you want to do that separately after everyone's been paid out, by all means, you go and buy individual stocks and all you want, and crypto companies, but don't do it with other people's life savings. I don't understand. Someone explain to me. I feel like I'm the only person who's
Hey, Tecmo. Hey, Tecmo, it sounds like we don't know all the details about the plan, but it does sound like there might be this toggle idea. So the people that want like 100% liquidity, they would basically, take the 20 toggle all the way over to the left and basically get a full in-kind distribution, I guess, in Bitcoin, ETH, and stables, but they would take like a 30% haircut, I think, on that distribution or the percentage they toggle over. So it's kind of incentivizing people to take some EST tokens or some equity, but there will be an option, I guess, for people that want to just completely get out versus don't. So at least my understanding. Other people, can share their views on that. So that's kind of how I see it. But I get your sentiment, Tecmo. I think some people, probably a good amount share the same.
So my
But
question now is, and I'm
liquidations are expensive, though, too. That's the problem. Liquidations take time and they're expensive, from my understanding.
But the primary reason that it's going down this path as opposed to that, whether it's a orderly liquidation or Chapter 7 or but a liquidating type Chapter 11, is because fundamentally the UCC and the debtor, and that really means that they're investment banks and financial advisors, have said that this plan has more value than a straight liquidation in an orderly liquidation, so that there's a higher recovery to all of us through this plan.
but
Hey,
That's
can I have one really quick thought on that, though? One really quick thought. So when you determine, say, a liquidation versus a plan, and you say the plan is they can argue it has more potential upside or more likely to make someone whole or whatever. It has more value. They have to also take into consideration liquidity and the value of time and people not having their money. I had a DM conversation with someone recently. I know, just so people can understand the importance of giving people their crypto back and give people their money back, because Celsius was such a unique situation. I talked to somebody who basically lost their kids and they can't afford to hire a lawyer to fight for their kids, because they don't have liquidity. So not giving people access to their...
I think
there's lots of terrible stories, and honestly, this is a terrible situation that we're all in.
as part of the confirmation process, the debtors generally have to show that the plan is in the best interest of a particular class of creditors, or for all creditors. And what that means is that you need to show that the recovery percentage is greater in the plan that's being considered versus a Chapter 7 liquidation. Now, when that analysis comes around, it's going to be interesting to look at, because I'm sure they're going to, they'll factor the time, the time factor into it, about waiting for recovery. But I'm sure there'll be a huge discount applied to, the liquidation of the crypto on hand, at present. And some of the crypto on hand is not particularly liquid. So you know, you will see that analysis. I mean, and we can, I guess, jump on a space and maybe talk about all the flaws in that analysis. But you do have to go through that exercise.
Yeah, and I think that's the crux of the issue, right, David and Yolo? Like, we haven't been presented with the value over here versus the value over here, and
Correct.
Right, but you will by March 31st in the plan disclosure statement. And one of the things that I think Plan C just made the comment on is future value versus present value. Uh, my recollection is all of this is done on a present value basis. So it doesn't matter if you have more upside per se. It's, you know, what is the present value now, and there are value judgments made as to what that future cash stream will look like, you know, in order to come up with the present value of, you know, the MSTs and the ESTs, for example.
yeah,
But I'll
so
guarantee you, you know, since I was on that side of the fence, that, you know, the people that pay for the valuation get the valuation they want. So those illiquid assets will get valued in such a fashion to show that there is a higher recovery from adoption of the plan than toggling to an orderly liquidation scenario.
yeah, so I mean that's like, you know, hiring your friend to do your home appraisal, right? And saying like, make sure it gets what I need.
Yeah, we can pull it apart though.
All right, but well, you can, but the and that will may affect people's votes. But you know, essentially, there is a lot of judgment involved in these valuations. And the first question you ask, you know, when you're doing one of these valuations is, you know, what are you using this valuation for? So the person who's doing that work knows which way to shade it. You know, if you're
Yeah,
doing it
I
for
just
tax purposes, it's very different than if
yeah,
you're doing it for, you know, selling something.
absolutely. So, but I guess my question is going to be, and we'll all just see it, like you said, once that comes out. But you know, I hope they are applying the fact that the value of that has to be applied against a 90+% failure rate. You know, you have to take a say whatever value you have and multiply it by 0.9 at a minimum, and to get a number over here, and then apply it to, let's call it a 50% haircut, you know, or whatever it might be for a liquidation, and then combine that with, you know, like as Plan C said, I don't know if we did a poll, how many people would take half their money today with a 90% failure potentiality of being 100% in 10 years? You know, like I just like that's, I don't know. I guess we'll see.
I haven't looked at the Voyager liquidation analysis, but I heard that if you look at it, the liquidation value is way less than the liquidation value of the actual crypto because of all sorts of expenses and discounts that are applied to it. I have, as I said, I haven't looked at it yet. I just heard that through the grapevine that the Voyager liquidation analysis was put a big discount in, you know, for crypto on hand and the liquidation of that. And I mean, with Celsius, obviously, there's certain crypto that one would have to sit back and, you know, figure out a time when it could be liquidated and what the expected price would be, because a lot of it's tied up. But that's one of the things that to keep an eye out on, for when we see a draft disclosure statement, is just to look for the discounts that are applied, and particularly to the discounts that are applied to, you know, the crypto on hand that is readily saleable.
Yeah,
So
I
that,
appreciate it, guys. I think we'll just know more once they present that, because then we'll
yes.
be able to make an accurate assessment of Tony Toggle versus, you know, liquidation, I guess.
Can I just defend the toggle here a little bit? Everyone's really
Wait. No, there's two toggles, Tony. So I think you're defending the AARP toggle that I'm hoping that I get some grace in, even though I'm only 62, versus the toggle to the orderly liquidation that is the UCC backup.
I think it's important to note that we'll all be AARP qualified once this is resolved. So
Good point. Hey, Joe, I think you were next.
Yeah, I just wanted to ask David, does the plan have to beat the value for each class? Because there's roughly 50% of the coins left. In the plan, pretty much every class would end up with more, aside for earn, which would end up with a lot less. We don't have that number. We've been trying to get a rough estimate, and it seems like it's a little bit all over the map. Between 25 and 45% would be left over in a liquidation. It could be like 50%. So if they end up giving, only liquid crypto of, let's say, 25%, and then you factor in the current value of the equity, I don't see how that would beat a liquidation.
I guess I'd say you have to see some of the creativity of the people who put together those reports.
Yeah, and I guess a follow-up question is, at that point, once we get the disclosure statement, it seems like a lot of this is very much momentum driven. So at that
Yes.
point, is it going to be easy for another bidder to come in and get the UCC and Celsius to switch gears, or to get them to switch gears to liquidation rather than going forward with any plan?
I think the latter is more likely than the former. I think that if large constituents.
Sorry about the space cutting out there, guys. I think everything's fine with my internet. It just some weird thing happened. I'm not 100% sure. But regardless, where was the conversation? We were having a great conversation. I'm trying to remember, trying to get everyone back on stage that was speaking so we can get back to what we were talking about.
Yeah, David was in the middle of a point.
Oh, okay, I'll try to get David back in the room if he's still available.
Simon and Yolo, I did send you a DM and I just posted into the nest some fresh data from Dylan LeClaire about the other side of liquidity, which is our exit liquidity and our ability to sell the asset share token on a secondary market. So Dylan LeClaire just posted something I hadn't seen before, which is fresh data on crypto equities in secondary markets in a marketplace I hadn't seen before, but it's basically showing some large tranches. If you have $3 to $30 million to buy some crypto equity, there's crypto equity like Consensus and BnkToTheFuture.com that you can get at a 70% discount on a secondary market. OpenSea at a 50% discount on a secondary market. So I know that doesn't go into the valuation of equity that we're talking about, but I just think it's an important point to see some fresh data, kind of in a bit of a bear market, what our crypto equities could be selling at.
Right. So, but I think that conflates the two issues that you just raised.
Yeah, I know it's a different story, but it's just something fresh that, I'm not, I know it's the other side of the equation, but it's something I think.
Well, it's because he's measuring, he's saying this is the discount compared to their last funding round, but the value of those companies has gone down because of the bear market. So that's a piece of it. And then there's another piece of it because there's a lack of liquidity on the secondary market. And you can't separate those two, how much of the discount is due to each of those factors.
Yeah, so I think
Gotcha.
Provenance, whatever blockchain, I think it's going to be, was it the first or second factor Yolo mentioned? Because it's going to be a very, very illiquid market. So even if the market is relatively, doing pretty well, let's say Bitcoin's at like 60,000, the liquidity is still going to be pretty dry because it's not a place that a lot of people go to buy equity.
Agreed, and I think Simon, certainly has some thoughts along those lines.
Yeah, definitely. Just don't think about it as a liquid market. It's not a liquid market. It's a misrepresentation. Unless there is going to be, in the Bitfinex deal, we had people that were shareholders and some serious people that were putting in buy orders on a liquid market because it was launched on the Bitfinex exchange. This is not going to be the same. So, don't treat it as a liquid market, which is the importance of getting as much upfront, because the rest is going to be illiquid.
Right. So if you choose to toggle, you have to do it with the understanding that you're going to hold this thing for the long term. If you're going to do that and then try to sell in a month or a year, you're going to lose a lot of money.
Well, it's going to be an income play. I still think this is best set up as an income play, not a growth play. You may get some growth, but I think you just need to mine until it's no longer profitable, run out the loans for 5 years, and if you have to have the staking, whatever the model they're going to come up with that, but the staking should be distributed and find another model, which there's been other alternative models proposed. I know those business plans have been sent in because I've seen them.
So, and also, if you read the plan closely, remember there's a disincentive to sell your ESTs in the first year, because if you actually sell your EST in the first year, trade it on the secondary market, then you lose the MST that's attached to it. So you want to hold it for at least the first year to maintain that MST, and then you can sell the two separately.
Yeah, and then you got the provenance blockchain, as you said, like at least put this on some kind of Ethereum or something.
Yeah, I'm for Algorand, just because Algorand easily lets you add new assets through this thing called ASA, and the transaction fees are so much lower than Ethereum. They're 1,000th of an algo per transaction, but I know algo's more orphan than either Ethereum or a number of other blockchains.
I mean, Algo's 1,000 times more developed than Provenance. But Algo is actually a proven model because we did it for Exodus. So they did the self-custody wallet at Exodus. They got it approved by the SEC. We then did the Reg A Plus offering, put through 75 million of transactions. We did 400,000 KYCs on Securitize. And then we distributed, we were investors in the seed round. We distributed a bunch of transactions through it, and it now trades on the Securitize ATS. So that's all been battle tested, and it's a proven model that we've already done.
We should just put it on the Cell Token Proof of Work network because it's the most secure. That way, everyone can get paid out in kind, and they can use that to pay the gas fees. That's the only possible solution where this works.
Well, that's Ethereum. It's just an ERC20. So.
All right, so we have to break off Cell Token into its own chain, and then it'll work.
Okay, I'm back. I had technical problems. Joe, did you get to go?
Yeah, I just add to what we were just talking about in terms of like income versus growth. So, I mean, just a quick analysis. There's about 1.3 billion worth of Ether. Sorry, I'm just pulling it up. And staking that would yield about 50 at 4% would yield about $52 million. Loans at an average of 9%. If my number is right, that's 411 in loans. 411 million in loans. That would yield about 36 million. So a total of about called $90 million of income. The mining we don't know right at this point, but assuming it's around 100 million and half of that is going just for management, there's not going to be that much left to give out in dividends.
Yeah, and plus that's just about the most inefficient way of managing staking you could ever imagine. It's like buying Bitcoin through GBTC. You only do it if you have to. But if you were just staking, you'd get a 15% fee on the stake, and then the coins are yours, so you can, and yeah, you wouldn't be paying on the upside. You wouldn't be paying a performance fee, and you'd have the ability to be liquid in that. So wrapping it into a fund, charging a performance fee, and then paying out a dividend after everything is just about the worst way of managing staking possible.
Yeah, and then on top of that, we're going to be paying out 10%, I think it is, in incentive fees, which could just, if Bitcoin goes up, doubles, they're making 10% on the value of all these assets just by holding it, which is probably the real play for anybody taking over if it's not based on like the current prices of, beating the benchmark of the current prices of Bitcoin and Ether, just holding it may yield the managers a tremendous amount of money. It's basically, we're going to be giving 10% away of any upside of our crypto for an indefinite amount of time.
Hey, Henry.
Hey guys, can you hear me?
Yes.
Okay, thank you for the time. So I'm going to very quick. So I just have a question for Simon Plency and Crypto Yolo because I think he's a lawyer, so that's what I kind of got.
I'm
So,
not a lawyer. I'm going to put that
oh,
disclaimer right there. Look, David
all right,
Adler's a lawyer, so if you want accurate answers, you need to wait for him.
all right, but it's gonna be opinionated, so you could answer that. So let me start with you since you're the first. Um, I know you guys talked about the clawbacks that are hard to do overseas. So maybe, he can come up and answer, or you guys can talk about it and ask him later. Is there a way that they could segregate it? Like if they do clawbacks in United States, then, people benefit in United States, and whatever they can do overseas in certain countries, that's how much, the percentage those people will get. Since if you can do clawbacks in China, then the percentage for Chinese people to get the money back is less than American people, obviously, because it's easier to do clawbacks. What do you think?
Well, let me repose it so David can answer. And I'm not sure that you can do that. But David, the question basically is: could you set up classes of creditors based on international domicile versus domestic creditors, given the disparity in clawback potential and recoveries?
I don't think you could do that, but what I do think will be embedded in the plan is that if you're subject to any potential clawback, your claim you will not get a distribution on your claim until you resolve the avoidance action. So that's some way to sort of get around going to the People's Ministry in China. If you have a Chinese resident on the platform who still has, $3 million on the platform, and that $3 million is not going to receive a distribution until the avoidance action is cleared up. That's one way of sort of getting around, you know, uh, you know, uh, all the foreign laws on preferences. You just tie up the distribution, in the bankruptcy court. So I think you could do it that way. I don't think you could do, separate classes of creditors based on location. I don't think that would work.
Okay, and Henry, let me just interject and follow up on a point that David just made here. So Kirtland's taking an aggressive position on that withhold issue. That hey, we're going to withhold from your actual distribution the potential amount of your preference claim, and they want to withhold the aggregate amount of your withdrawals during the 90-day period, as opposed to the net amount of your withdrawals during the 90-day period. So how aggressive do you think that is, and can that be changed from the aggregate to the net amount?
That's a question for David, right? Not me.
Yeah.
Oh, it's for me.
Yeah, because you raised up the we're going to hold on to everything until we actually know how much to pay you issue.
I mean, who's going to be objecting to it? The people who object to it are going to, end up, showing up in bankruptcy court, right? I think generally it should be a net position, not an aggregate position. But it's a way to sort of, I think, deal with the some of the international issues. I don't think it works. I think it should be based on a net amount. But if you're going to put it in the plan and you're going to work off of aggregate amounts, you're sort of forcing everyone who still has money on the platform to, enter into a discussion to resolve the avoidance claim, so that, your claim will no longer be subject to disallowance by virtue of the fact that you received an avoidable transfer. It'll tie it up for a long time for those who want to fight it, I mean, for those people who have, let's use examples, who have $10 million on the platform and a $200,000, avoidable preference. You might just get those people paying the money back so that they can get their distribution based on the 10, or if it's a higher preference amount, say it's $1 million or $2 million, right? I mean, those people might actually litigate it so that they can get their recovery based on the $10 million.
Okay, so that clarifies that. I got one more question, but that could be for lawyers or Plan C. I mean, two questions, but they're very quick. So a lot of people are sometimes just advocating Chapter 7 or liquidation, but they forget that liquidation doesn't mean no clawbacks. And if I know correctly, clawbacks could be actually much higher than the proposed one if we go through liquidation. And as we see for Binance, everybody wanted to be in that plan, and clawbacks are there anyway. So what do you guys think about that one?
No, you're 100% correct. There will be clawbacks if it gets liquidated. And actually, one of the things I keep trying to point out is that one of the features of this plan is that it actually, as opposed to saying, hey, you're going to be clawed back, it actually says, hey, these people are not going to be clawed back. So that's a big difference between the two scenarios. So in other words, under the proposed plan, if you're a creditor, which means you have more than $10 on the platform, and your preference claim that you're subject to is $100,000 or less, and you vote for the plan and you sign the releases against everybody, then you're exempt from a clawback.
And even then, but even over 100,000, they're asking for 30%. But in chapter
27, 20,
27,
20. So if you look at it under 100,000, if you vote for it, you're scot free. 100,000 to 250,000, 27.5%. But this aggregate versus net matters, whether you're, for a lot of people, whether you're in 100 or 250. Between 250 and $1 million, it goes to this litigation subcommittee that's appointed by the UCC of 3 people to decide whether or not to pursue you. And it kind of implies that if your preference action is $1 million or more, that it's likely to be pursued.
yes, and one thing I would just say, like, when anybody comes up on the platform and keeps screaming, like, why don't we just go to chapter 7? If some of you lawyers could, like, just point that out, like, look, be careful what you wish for, because you could actually get 100% clawbacks, and I don't think anybody be happy with that versus 30% or whatever percent, right? And I want one last question. I don't want to hold you back. One point, because there's also a lot of people like screaming about the 81 cents token, sell token. I don't even have sell token. I think it's fair to give him 81 cent percent. But then some of people say like, oh, it's not fair because there were squeezers and lemons and whatever. But here's the question for Simon, actually. Simon, don't you think even if there were insiders that benefited for the short squeeze, which we know the short squeeze had a different purpose. It had to liquidate FTX. But anyway, even if there were short squeezers and insiders benefited, don't we benefit? Because if the insiders sold their sell for higher, let's say they sold it for $1.50, and they're going to be clocked back even maybe up to 3 years, we're going to get that money back anyway. So, and actually more, because there was a short squeeze. What do you guys think about that one?
So I think Simon should answer this, but let me just point out that the value of the clawback is the value of the token at the time that it was taken off the platform. So it's not, the 81 cent sell versus 20 cent sell debate has nothing to do with the value of the preference claim.
Yeah, and also my plan had 81 cent sell, so I don't think it's really a question for me. It's more a question for Celsius.
Yeah,
I gave them 81 cents.
yeah, and I think it's fair, and I just don't think like it's fair for people to just keep yelling at the people that were in short squeeze, because short squeeze had different purpose than people think, and I wasn't part of it. I don't have sell, not even one, but I just think like to be screaming at those people is completely not fair, and like we said, like, because some of their points is like, oh, because the insider benefited, even if they did, we're gonna get their money back anyway, so it don't really matter on the scheme of things. Thank you, guys.
Thank you, Henry. Pumper Slug.
Hey guys, thanks. First, I just want to throw my support behind Tecmo's sentiment. But second, and my question, I guess, is and I don't know if this is true with all the classes, but at least in the borrow class, excuse me, language is written that if you vote no on the plan, then it limits your options. Does anybody have any further info on that, whether that's copacetic?
Yeah, I also think it's worth noting that one of the major features of clawbacks is to bribe you to vote for the plan. The convenience clause and the limiting your clawback exposure is all about entering into a negotiation. That's one of the key features of it. Then it goes to what the litigation trust can do, I think.
Yeah, and I get that, but this is more like I vote for the president, and if the other guy wins, they kick me out of the country.
I mean, I think it's generally referred to as the death trap provision, where you have to vote in favor of the plan in order to get a specified form of treatment. Oftentimes, those death trap provisions are not looked upon favorably. I think as we get to a disclosure statement and a plan, some of those issues will be hashed out. I mean, to the extent that a death trap provision is not valid or not allowed under Second Circuit law, one would argue that the plan itself is unconfirmable as a matter of law because it does contain this death trap provision. But that's something that we'll have to see as the disclosure statement and the plan are ultimately put on file, how they phrase it.
Okay, excellent. Thank you, David. As long as you're aware and hopefully advocating for us, I'll leave it there. Thanks.
Okay.
Thank you for your questions. I just wanted to let the room know that we don't have anyone waiting, so if you'd like to put in your request now, I'll let you up on the stage. Crypto Noob?
Hey guys, how you doing? Thanks for running the space. You guys also make some banger workout music, so it's good stuff to listen to. But anyway, my question is regarding clawbacks.
This motivates you for your workout?
I mean,
this is awful music.
It really just gets me angry, and so
yeah. All right. So you hit the weights harder.
Yes, just the rage helps me to pump the iron. Yeah. Anyway, my question is regarding clawbacks and just Judge Glenn's position today. So basically, I know after he talked, a lot of people were just losing their minds, like you said, saying he's all for clawbacks, and you cleared that up. Basically, he was just saying like, yeah, this thing exists, so it's something we have to deal with, and when we're dealing with it, we will deal with it. So in Judge Glenn's, for his type of just where he is as a judge and what he's supposed to be doing, is he someone that would say to the UCC, hey, you guys can do clawbacks, but we are not going to have this 100K threshold. We're actually going to claw back everybody. So he may like set the terms for how the clawbacks happen. Or is it that he's just saying, okay, whatever you guys want to do, if I approve the plan, whatever you want to do with the threshold and all that, then that's up to you. Like, where's Judge Glenn's kind of place in setting terms or just
the latter? It's the latter. I think that deference would be given to the decision, the economic decision of where to, where a clawback action becomes viable versus where it's just, a harassment action. I don't think that, you're going to hear the court say, well, if you apply it to one, you have to apply it to all, and you have to chase the person who took, $25,000 off the platform, regardless, of the monetary threshold. I think that type of issue is left to the business judgment or the analysis done by the estate fiduciaries and their professionals.
Gotcha. Okay. So he would just basically go with, whatever the UCC plans with Nova Wolf as this is the plan. Okay, so we're going to go forward with this.
And the debtor. Yep.
Gotcha. I appreciate it. Thank you.
Hey, David, when do you think the judge is going to actually make a decision or really address clawbacks? There's obviously settlements that are in the process of going to the judge. I believe March 21st or whenever the next court date is. for custody. Obviously, we heard today that Withhold either made a deal or is working on a settlement. I'm not sure where you stand, David, with loans, but the point is like, is the judge going to rule or pass these settlements, these ad hoc settlements, before ruling on clawbacks? Is that part of the process?
I mean, the settlements will be approved without a determination on clawback. So in order to approve a settlement, you just have to find, the bankruptcy court has to find that it's above the lowest point in the range of reasonableness. Obviously, there's uh, for some, there's a prima facie case for a preference, and then there are all these defenses that need to be hashed out. So it's very uncertain what the result would be. And if you have in front of you a proposed settlement that's resolving all the issues, between the group and the estate, I think it's pretty easy to make a determination that the amount of the settlement is above the lowest point in the range of reasonableness to approve it without addressing the merits of either the preference claim or the defenses. So I don't think there'll be a ruling until the issue is properly teed up, where someone is alleging a preference and the other side is arguing either the safe harbor or ordinary business terms or whatever. That's when the decision will be made, initially.
Not sure if you can even make your best New Jersey guess on it, but when do you think that I understand your position on settlements, but when do you think that we'll actually really get into like the clawback stuff with the judge? If you 6 months, a year, what do you think? Before the end of the year?
I would say it will be after confirmation. And I didn't give my view on this before, but when Kirkland went through their timeline of getting this case confirmed and effective within a year, I was a little skeptical. I'm skeptical because not because of anything that Kirkland's doing, but simply because generally to go effective, you're going to need approval by a bunch of regulators, and regulators work at their own speed. So I'm not quite certain that this notion of an effective date happening, before the first anniversary of the filing is doable. But I would suspect that the clawbacks would come after plan confirmation. And so that would be, towards the end of the year, assuming they get the necessary votes and they can go effective in the third quarter of this year.
So David, do you think the Voyager experience has any impact on that regulatory outlook?
I do. I think that the SEC will be a little bit more prepared if they come forward and start objecting to the Celsius plan. They're going to have to, not just come in and say, "Oh, it may be an unregistered security." I think that they're going to have to point to some view of theirs that supports that position, and not just simply come in and say, "Now we don't want the plan confirmed because it might involve unregistered securities." That's our objection. We're the SEC. That's our view. I don't think they'll do that again here in this case.
Well, this one's interesting, David, because the sale token was originally filed as a Form D, so it is a security.
Right.
But it was illegally trading on crypto exchanges where none of them had, and it was sold to retail investors without filing an S1 and all that stuff. So it wasn't unregistered. It was just registered and illegal.
Right. And I mean, don't you think they're going to come in and say, and I'm not even talking about the SEC, I'm talking about a place like the state of New York where you need a BIT license to engage in any type of crypto business. Don't you think that New York is going to come in and say, this plan does not comply with New York law because it's setting up a company that's engaged in crypto and doesn't have a BIT license? I mean, there's going to be objections of that type from not every single, but many state regulators. And I think if you look at Voyager, and I am not. I am not involved in Voyager, but I've been watching it a little bit more carefully in the last week. Apparently, the state of Vermont had sort of made some argument that uh, the plan was illegal, and because it didn't comply with Vermont law. I think Vermont ultimately caved and said, "Okay, we'll go along with this." Um, uh, After the SEC got beat up for 2 or 3 days, but I expect a lot of that too. I mean, the regulators have been very active in this case, and so I think that we're going to see a lot of objections.
Yeah, thinking ahead on those. So the Figure ATS is not actually authorized to perform crypto transactions yet for crypto securities. So it's a regular broker dealer with an ATS that hasn't performed a crypto transaction. So you've got no broker dealer has got. So you have to have two things to do it. You have to have a broker dealer that's got the virtual asset permission, which they don't, and then you have to have an ATS, and the broker needs to be registered as a special purpose broker dealer. So whether they can fast track that through this process would really depend upon their relationship with the SEC and regulators, but I don't think they've got a desire to do that. So there is still that massive elephant in the room
Yep.
around this. Yeah. And unfortunately, security tokens, you got security tokens, you got staking,
Right.
you've got sell token. They're just cascading the complexity in terms of the challenge of the mission. That's why we really wanted to avoid the security token piece, but we started introducing all the security token players because like the securitized ATS has actually done these deals and got them through, and they've actually done one with Exodus that got SEC approved. So there's a proven model there.
Yep. I mean, as you said it, Simon, there are cascading levels of complexity, both with operating the business sort of as a standalone, but then you have the added complexity of the tokens being issued. You have probably other securities laws issues that get implicated with NUCO, like investment company acts, stuff like that. So, I mean, there's just layer upon layer of complexity. And in some ways, I guess we should
Plus
all be
hash token as well, David. Sorry, you
yeah,
got a company that has a utility token. The utility token argument
right.
doesn't really stand anymore. But that those ones I think is where the VGX and hash token is a very comparable.
Right.
Is a comparable like for like. Cell token is not comparable to VGX given the background of what's happened. But I think the judge could overrule an objection around if they tried to use hash token
right.
as one of those using the VGX case. But I just don't think the cell token and VGX are comparable, given that it was registered as a Form D, it had the examiner report, just so many other,
yeah.
and the price was manipulated. So
yeah. I mean, all I was going to say was I think we should be happy in some ways that the SEC battle took place in Voyager first, because it will probably make things a little bit more clear when we go forward. I don't think the SEC is going to be coming back in Celsius and making the point that the plan should not be confirmed because there may be an unregistered security involved here. They just haven't decided that point yet. I mean, Judge Wiles really gave the SEC a hard time, based on the articles I've been reading about the arguments that were made by them. So hopefully we avoid that. Hopefully a lesson was learned in Voyager that doesn't come over to Celsius and just waste gobs of money and time.
Yep. Crypto Miami and then Nati.
Hi, David. I just had a quick question about the relationship between the loans ad hoc and the litigation trust. it's a little clear in the documents that, I mean, obviously, since the earned people will get the asset share token, but that the litigation trust proceeds will actually exist outside the asset share token and will be distributed to the earned people. I saw that. But are the loans people, if we filed additional claims, I mean, do we still get distributions from the litigation trust, or are we like made more whole and we lose access to additional claims?
I think the thinking is that we are being made more whole, so we would not get distributions from the litigation trust. However, the borrowers have certain claims, of their own against Celsius and the directors and officers, and how those claims ultimately get treated and monetized is an issue that has not been resolved yet.
Hey, David, was this your whole thing about why to submit a claim form? Is this coming into play?
Yes. I mean, actually, let me back up and just make sure that I, sort of put it in context. I was talking about filing claims because the claims of the estate against the directors and officers are subject to certain defenses that would not exist if, Crypto YOLO brought a direct claim against the directors and officers. So I was suggesting that everyone file claims, so that those claims could eventually be assigned to a litigation trust and pursued in that way without having, these affirmative defenses that might exist raised by the defendant, director, and officers. Hopefully that makes sense.
Clear as mud.
Okay, that was my whole point.
So also, I did take David's advice, because I always listened to David and did file a claim form, so to preserve all those claims. But if I take one of those settlements, I have to give up all those claims. And I wanted to ask, why instead of releasing those claims, why couldn't I be forced as part of that settlement to contribute those claims to the litigation trust?
It's a great question, because I was going to actually file something to the stipulation that said it should be addressed, because there were, in the stipulation that got approved today, there were paragraphs that dealt with what a plan would look like. And I was going to put a response in that said something to the effect of people who vote in favor of the plan, agree to assign their claims to a litigation trust. And, if the proposal that's floating around on the term sheet says that, in order to, get your earned recovery, you're releasing those claims, that needs to change. Because the individual claims, generally they're packaged together, the estate claims and the individual claims. But it would make no sense to release those claims as part of a settlement with the debtor. You would wish to, it's in everyone's interest to assign those claims, back to the debtor, so the debtor or the estate, so that the estate could pursue them, post bankruptcy.
Okay, Natty?
Yes. David, regarding the comeback of your complaint, in the timeline, what we have right now is 31 March, we have disclosure statement. And then the next hearing is 17 April for the sale hearing. Where the loan complaint to claim the collateral is the title of the borrower and not the estate will come into play. It will come after the bankruptcy. When do you accept your complaint to be addressed by the judge?
Assuming there is not a resolution of the issue, I would expect this issue to be litigated in connection with confirmation.
Okay, at the very end then.
Well, before the plan gets confirmed. And we're looking at, a confirmation date of sometime in June. It would need to be litigated and decided before the plan is confirmed.
Okay, thank you.
Thank you, Nati. Webb Ferret?
Hey guys, thank you very much. Two-part question. First one's going to be kind of quick. What can we do as a governing body or as a committee to put pressure on those who have the power to, I guess, enforce the criminal actions against Mashinsky and his band of insiders now, as opposed to them continuing to float free and look like nothing's ever happened? What are your thoughts on that? Is there anything that we can do, or is it something that's just going to have to run its time and, I guess, wait for it to fall into the proper hands?
I would say the latter. I believe that the relevant authorities in the federal government and the state are already investigating this. I mean, I guess it can't hurt to try and tell them your story, because they get
Hey,
to put
David, if
context.
I can interrupt you for 1 second, I think Tecmo might be able to answer that question
Okay.
a little clearer.
No, I
Tecmo?
mean, David, you were already saying what I was going to say, but essentially, if you want to put in a claim, feel free with ic3.gov or other, call your local FBI office. But the majority of all of that is, they probably are already well aware of the situation. There's, I can't speak to whether or not there is a current investigation, but they probably don't need anything else at this point. I mean, the examiner report itself would do a much better
Right.
job than you would. No offense.
Right.
Yeah, it's just kind of sickening to see, him running around free and the rest of us in here having to deal with the damage that they have left behind. So I guess, the sooner the better they can do with that. But thank you.
I'm under the belief, and David, I don't know if this is the correct legal term, but I'm under the belief that he's already received an indictment. So take that for what it's worth.
I mean, are you talking about a sealed or unsealed indictment?
Yeah, thanks, Tecmo. Good question. I have no idea. I don't know. I just, I'm a guy in Web3, and I was told that happened.
Yeah, I mean, I don't know about that, but the one other thing that I'll say is if any of you are like SBF on here and are political contributors, and you've ever contributed to an attorney general campaign, you can use that influence, because unfortunately that is kind of the American system, and advocate with the local attorney general to expeditiously bring charges and investigate and bring charges as appropriate.
Second part's going to be kind of quick as well. All the talk about litigation trust, the funds and money that'll be received going towards that. What's to stop the same criminals that put us where we are now to hide the funds that they currently took out of the platform? And what's the chances of us getting anything back from insiders? Institutions, possibly, depending on the amount. But I mean, they put us here to start with. Unfortunately, they can hide those funds and do what they will with them, declare personal bankruptcy, whatever. But consensus on what's the percentage of the chances that we'll ever see a dime back from the insiders? Thank you.
It's a great question. I mean, with in the American system, frequently you see people, shielding assets from judgment creditors. You have to assume that the people who are being named in the complaint drafted by the committee are probably, undertaking certain efforts to shield their assets. But generally, my view is that there's insurance floating around in the background. I don't know whether it covers that which is being alleged, but it would be nice if it did. And I think, with respect to some people, usually the smaller people, are more likely to pay something at the end just to make it go away and to get, move forward with their lives rather than having, this litigation hanging over their heads. The price of litigation, and especially this type of litigation that's been teed up, is simply enormous. I mean, the cost of it for the defendants. So I think, my sense is that something will be recovered. It's not probably going to make a lot of people on this call happy, but you know, I believe that there will be a recovery based on what I've seen.
But also another uniqueness is that this is a financial institution where the assets existed in Celsius under, Koala 1, Koala 2, Koala 3, AM Ventures, Alex Majinski, all of the others that were listed in the UCC investigation. Now, that data exists within Celsius. And then you have a blockchain analysis that goes from there, and you can see which exchange it went to, and various other things. So normally when you're in, obviously he'll have a bunch of assets everywhere else, but if what he said is true, which nothing is true what he says, but if he says what is true, a large chunk of his wealth was on the Celsius, and then you would have the financial records that go from there. And so really it's similar to what they're doing in the Jason Stone case. You can try and trace out those assets, but I think it's slightly unique in the if a bunch of the assets started at Celsius, and we know all of the different trusts that are set up because they all had accounts on Celsius, that can at least trace through a bunch of wealth.
Yeah,
And I think that that's a good point, Simon, because I'm sure that the various, especially the top several people, have engaged in whatever asset protection strategies they could. Don't know the timing of them, but the blockchain does provide unique transparency. And the UCC has already has drafted a draft complaint, and so it looks like they're ready to roll pretty quickly as soon as they see it's appropriate to actually file that in court and start that proceeding. So it seems like it just like it's every day closer to us getting out of this nightmare in terms of exiting with a plan. It's also every day closer to the people being brought to justice and facing the consequences who put us in this disaster.
Yeah, I just wanted to add something real quick that I'm a former member of the virtual currency response team at the FBI. Like they have people that know what they're doing over there that, can trace all these funds on chain very well and get more information than you guys realized with search, warrant power to really bring that all together in one package. If something is happening, then I'm confident in their abilities. Just something I wanted to say.
And also, I think I heard one time from Chain Analysis that actually 80% of their business was from law enforcement.
Yeah, I don't know the numbers, but I work very closely with Chainalysis and TRM. TRM is actually my favorite tool. They do many more blockchains better. Let's just say it that way. But yeah, like it's a huge cohesive effort between exchanges, law enforcement, the tracing tools. It's a small community, but we are constantly talking with each other.
Hey, Tetmo, can you apply for the litigation trust committee?
I don't want to be a part of any committee, but what do you mean? I don't even know what that is.
The litigation trust, they're opening up applications for committee members, creditors that want to be a whole part of the insider clawbacks and stuff like that. Love to see you on that
Okay.
board.
Yeah, I'll look into it. I hear committee and I get like PTSD. So,
and I just like to give a thumbs up to Tecmo's first question. Give us all our liquid crypto back. Let's get the hell out of this bankruptcy. No to Nova Wolf. I'm sorry, I don't want to go into a venture capital fund. Take the illiquid stuff, gamble with that, but give everybody back their fair portion, and let's just get out of this mess. Thank you.
Thanks for your questions, WebFerret. Flat Ace?
Yes, hello.
Hello.
Hi, everybody. My question is regarding clawbacks. I think I saw somewhere that Kirkland and Ellis stated that in order to calculate your clawback exposure, it would only be based on withdrawals and not on deposits. Firstly, is that even legal? And secondly, what do you guys think that the judge withdrew for this calculation? Because I always thought that clawback exposure would be based on netting. Thank you.
I'll take a shot at answering it. I mean, I think that Kirkland has sort of taken the position that all they need to do is show a prima facie case for a preference, which is, a withdrawal, a transfer of property that the debtor has an interest in within 90 days of the bankruptcy filing that allows the creditor to receive more than it otherwise would receive in a Chapter 7. And that's what, their quote prima facie case is. Netting would be basically new value under the preference defense section. So, the creditor who is faced with a preference action would say, well, I took 300 out, but I put back in 200, and that should be a credit, right, under new value. And then you would get into all the other defenses of ordinary business terms, safe harbor under 546E. I think from their perspective, though, they're just working from sort of the prima facie case, and they're not giving the benefit of any types of credit at the moment for purposes of what they're doing. Generally, by the way, when this stuff goes to ADR, so I mean they're trying to set up a procedure where there's a streamlined alternative dispute mechanism. When that happens, generally you see the party that's pursuing the claim, deal with new value and ordinary course of business, things that you can actually put down into a number. There are the threshold questions, the legal questions of whether, the safe harbor provision of 546E applies. And we had long discussions about that back in August. That's going to be sort of like, I imagine, one of the issues that has to get litigated first by some group of claimants in order for the rest of the process to move forward. Because if the court rules that 546E applies to withdrawals, that's a defense to the preference action.
Hey, Plan C, do you want to give any kind of update on the Telegram group's activities with counsel?
Not specifically. I mean, the group's definitely growing substantially, continues to grow. Lots of hard work in the background. I mean, the steering committee is just working around the clock with Deb, getting everything ready, preparing. Well, people have to understand, like, this group was formed 7 months ago, so in preparation for whatever's coming. And there's a lot of coordination. It feels like everything's going to happen overnight, but this is going to play out over a longer period of time than people think. And so there's plenty of time to be prepared and organized for whatever people decide to do, whether they decide to litigate fully or they decide to do some sort of a settlement. That's up to every individual. But the main point is we have a strong group, and the whole point of the group is to band together and basically save on costs and get like a 10x defense for 100th of the cost, right? For the people that choose to go full litigation. So, I think it's the best place. I haven't seen anything else like it. So if you're exposed, join the group, get involved. There's an updates channel where you don't have to be involved in the daily chat because that can be a lot of speculation, but there's a channel just for direct updates from the steering committee and Deb. But that's pretty much it. One thing I wanted to ask David really quickly is, just so people understand, because there's a lot of questions around this topic of new value and they're kind of setting this up as casting the widest net, but in the end, there will be some sort of offsetting. But my understanding is, like, say there's two scenarios here. So somebody deposited crypto within the 90-day window, right? So within the 90-day window, they say they had nothing in the app. Within 90 days, they deposited, say, $100,000, and then they remove that same $100,000 within that 90 days. Comparing that to a scenario where somebody had $100,000 in the app for, say, the last year, and then they removed $100,000 and then they deposited $100,000 back in. It matters about the course of your transactions. As far as I understand it, it's the sequence, right? If your last transaction was a deposit, then the new value defense would say, okay, you removed 100K, but you put 100K back in, therefore your exposure is zero. Whereas the person that deposited within that 90 days and then withdrew, they'd have 100,000 of clawback exposure, correct? I just wanted to like understand that.
I believe that's correct. In other words, you look at, the timing of the preference and what happened thereafter. If you're looking at it from a 30,000-foot view, you might say that you're just looking at net exposure during that 90-day period. But I think that if once you work off of the statute, probably you would look at new value after the preference has taken place. I think that's probably
yeah. I know it's hard. You can't give specifics, on this call, but like,
I'm not sure that the law is completely clear on that, to be honest with you. But
okay, because the point of talking about that, and we'll get to other topics here, but it's just so people understand, like, because someone would say, well, I deposited and then withdrew, and the other one is someone withdrew and then deposited, and people would say, well, it should be netted to be the exact same, but it does matter the course of the transactions. If the last one was a withdrawal versus a deposit, my understanding with new value is there is a difference there. But again, these are questions for lawyers, and it's not fair to get David to give us advice, lawyer advice on a call. So yeah, maybe we'll go to other topics. But this is definitely a question a lot of people have is this whole gross versus netting and why they're deciding to look at just withdrawals and not deposits. But anyways, we'll continue on.
Vlades, did we answer your questions?
Yes, thank you very much.
Thank you so much. RC?
Hi, I had a follow-up for David regarding the proof of claims. Kirkland had that statement about the reconciliation process where they were basically encouraging people to withdraw their extra claims. And in their test cases, they were objecting to all the claims. I'm just wondering how we should sort of consider that, given the potential they might be helpful if contributed to the estate.
I thought you were saying at first that Kirkland was encouraging people to withdraw duplicate claims filed by individuals. So some individuals, filed a proof of claim once, and then they filed a separate proof of claim.
Oh, is that what they mean by extra?
I think that's what they're talking about.
Oh, okay.
I don't think, listen, they recognize the issue that direct proofs of claim, against individuals or against the company and then against the individual have less defenses than the estate claim against the individual. I don't think they were suggesting that those claims be withdrawn.
Oh, okay, gotcha. Yeah, because I was confused because I also saw those test cases where they were basically objecting to everything. I think they picked out 3 people where they're
Right.
Okay.
Right.
Okay, great.
They were the 3 pro se's, right?
Yes.
It was Frischberg, Manny, and Rebecca, right?
Yes. Okay.
Yeah.
All right. Thank you very much.
Thank you, RC.
Sorry to go off topic, but Silvergate has just gone into voluntary liquidation. That's really bad news.
Wow.
That's really bad news.
Wow. What? That's crazy.
Simon, were they FDIC insured?
They are FDIC. They're a full fractional reserve bank, publicly traded company, that bank was our friend. They were actually a really important part of the ecosystem. It's really sad.
I'm sorry, Simon. Which bank was that?
Silvergate.
Silvergate, one of the major crypto-friendly banks that really helped us as an industry get US dollars into, companies like Binance and all the other companies that made our ecosystem and Kraken and everybody. It's actually really sad.
Okay.
Hey, David, quick question, because Silvergate was possibly on the hook for huge fines with FTX, like Madoff. Yep. Like I think JP Morgan had with Madoff.
Yep.
When they liquidate, are those fines just gone, or does the buyer eat those? I'm assuming FDIC is going to take over, and then I heard rumblings of like Wells Fargo basically buying all the assets.
Right. I mean, there would be deposits would have the FDIC insurance. The claims for example, by the people, the creditors of FTX, would probably go against some separate non-depository fund of assets to the extent it exists. But this is big news. I mean, when the FDIC steps in, and takes over, that's a big news day in the bankruptcy world. And I mean, it's really no surprise. I mean, there's been rumors going on about it forever since FTX imploded. I mean, and there were, by the way, a lot of people at who were in the process of getting their money out of FTX, and it got stuck at Silvergate. So and just it never got processed. There's a group of FTX creditors, ACH creditors, where the ACH made it to Silvergate but never made it to the customer. I have no idea how those claims actually end up getting treated. That's news.
Yeah, about 8 weeks ago, I gave a video on my YouTube channel on the serious consequences if Silvergate goes down. Yeah, it's not good.
Yeah.
What do you think is the first major thing to happen now that this is?
I'll tell you one thing, though. I don't think, here, mark my words, I don't think Silvergate's going to be pursuing preference actions against depositors who took out money within the 90 days before the bankruptcy.
Well, there you go. They'll move into a proper swift process, right?
Right. I mean, it was one of the things that, in the beginning of this case that, I wondered about, because I've been involved in a bunch of broker-dealer liquidations, SIPA liquidations, on behalf of the Chapter 7, the SIPA trustee. And, when I saw that up on the board at the first day hearing, can we go after people who withdrew funds? I literally, it struck me as not making sense. So I, went back to my firm, found some of the old timers who worked on these cases with me, and asked them, did we ever bring any preference actions based on in those cases? And the answer was no. And the answer was no because of the fact that there was insurance. And so it all sort of became a moot issue, where there were claims, and this is the same as Madoff. If you look at Madoff, you'll see that the 95+% of the claims that were brought in Madoff had to do with fraudulent conveyances. That's in part because Madoff was a Ponzi scheme. Occasionally, the Madoff trustee threw in a preference count as well. But I think if you were to try and look at Madoff and try and find cases that were just solely based on preference, in other words, that someone who took money out within 90 days, I think there would be very, very few of those cases.
A bit of an update. I retweeted Bitcoin Magazine, who was the one that said they've gone into voluntary liquidation, and they've just deleted the tweet. So I don't know what that means.
Okay.
But isn't the real question here is what firms still have exposure to Silvergate? Because FDIC only covers you to to 250 to K. And I know Coinbase and others had pulled back their exposure.
All of them,
which drew down on their assets. But there's got to be people in the environment that have more than 250K who are going to get impaired.
Yeah.
Yeah, and where would they have moved the funds to? So the Signature seems like it's its own mess. Metropolitan Bank said that was the bank behind FV Bank, which is one I'm a shareholder in. The only USD rails now is Deltec, and anyone that's on TradFi, it's a TradFi takeover, and we're seeing that with Celsius.
And what's the status of BNY Mellon? Because I know at one point they said that they were going to custody BTC at least.
Yeah, they'll custody Backed or any of the TradFi players, I'm sure, but we haven't seen anything with a crypto player.
Crypto Girl?
Hi, thank you, Mary. I want to go back to the additional claims topic because I'm one of the people that's been singled out to be heard first, and literally They want to disallow every single additional claim that I filed, and I filed 13 additional claims. They said that I didn't plead them sufficiently and thought of excuses to kick every single one of them out. And they said that they want to disallow it with prejudice to the extent that it requests amounts in excess of the value of the cryptocurrency associated with the account, or they want it to be reduced to zero. So I'm just wondering what will be the consequences of this. Obviously, I'm one of the first, and they're going to do this to everybody who follows, reduce the claim to zero or just kick it out completely. So does that mean that when you do get into the litigation trust, that being whole will only be the amount of coins that you have in your account, that you won't have any compensation for the litigation trust for all these additional claims that you brought?
I think that it's I think that I understand the part that for voting purposes on the plan, your claim should be allowed as your crypto amount. What I don't understand is why they would seek to disallow the claims that you asserted against Celsius. And especially if I heard you correctly, and I remember reading the objection, that most of the objections were premised on the fact that you hadn't pled the elements related to those claims. Typically, a court would allow you to amend, just as a court would allow you to amend a complaint. And it's pretty hard for me to see how, a claim could be dismissed, brought by the customer on, say, consumer fraud grounds, because the consumer fraud provisions are generally, that the company engaged in false advertising, and the plaintiff was damaged. I don't know what they're thinking, to be honest with you. I think that a resolution of it would be something to the effect of, for voting purposes, you vote your crypto claim, but your claim for consumer fraud is preserved and is transferred over to the litigation trust, because they can just as easily add, Mashinsky to that, or anyone else, and pursue it that way. The litigation trust can pursue it that way. So I'm at a loss sort of to explain that action, that claim objection.
Right, but what I don't understand is if they're going to transfer the additional claims to the litigation trust, will it result in making you whole ultimately? Because all the haircuts that we're going to get, which lock us in at this much lower rate, will go away, and you will have the ability to be made more whole when those claims start to come in.
Right. I mean, I would think that the trade would be that you assign your consumer fraud claim or whatever fraudulent inducement claim to the trust. The trust pursues it, and everyone shares equally in it, in the sense that unless there's some really, really egregious example of conduct, I don't think you want to pursue the claim against third parties, but you want someone to pursue that claim, and with the idea that that claim is valuable for someone who wishes to pursue it, and goes to giving people additional recovery and making them whole. You know what I'm saying?
Right.
Does that make sense?
Yeah.
But I think
There are people who have unique circumstances here. So I think I recall the pleading that you're referencing, where Kirkland said, "Oh, everyone was victimized here. Everyone is a victim of consumer fraud," and that's true in some respect. But I mean, there are other people who literally had direct communications with, employees, officers, directors of Celsius, and receive representations from them that put them in a unique spot, different from the general group of creditors. I don't know why you would want to disallow those claims, or even for that matter, the claim of every individual that the company engaged in consumer fraud.
Yeah, but still, the concept of being made whole, unfortunately, I think it is honestly just a wish for all of us, right? There just isn't enough way for us to be made whole, even if you add up the D&O and add up, whatever assets you can attack of the insiders, the whole is too big. And so it's all about maximizing recovery. And so if you do have some of these individual claims like you may have and David's talking about, your recovery may be a greater fraction of them. But unfortunately, I think we need to let go of being made whole. And the other side of it is, if we actually do get made whole, that means that there's more assets than are necessary to make us whole. And that's when the preferred would potentially have a much better case to actually get that upside.
Okay, yeah, thank you.
Thanks, Crypto Girl. Harry? Hey, Harry.
Hey, how you guys doing? I have a couple of things. Well, the first main one is regarding what was brought up earlier about these, I guess, C-suite. Alex and his bunch of friends or whatever that was running Celsius, right? If they did an OTC trade, there will be no way for us to, or can they, or is there a way to track OTC trades as they hide the wealth they received from us and basically fly off into the moonlight as certain images has come online or on Twitter?
Anybody?
If someone does an OTC trade that's not on the blockchain, that's not transparent.
Well, Tecmo, maybe you can answer that.
Yeah, I just invited him up.
Yeah, because I'm thinking, right? I don't believe that if everyone knows the blockchain is transactional and transparent. What's occurred or what has happened has now caused irreparable harm to a lot of people. And I'm saying that if these individuals can actually be brought to justice, especially if they do OTC transfers to hide or mask their criminal activity. Tecmo?
Yeah, so I alluded to this a little bit earlier, but the on-chain stuff is great because it's easy and public, and it's right there. The other side is just traditional crime fighting of subpoenaing financial records at various banks and things like that. So you maybe if someone tries to hide a transaction, you can still see it show up somewhere, generally in something that they own, right? So it's a combination of traditional crime fighting and on-chain analysis.
Okay, so all right. So there is a way to track the money movements, right?
Like, let's say they have a $25,000 transaction OTC, or something, right? And it eventually gets placed into some bank account that they own. Well, then a STAR is going to be filed, and we'll also, have all of those records of finances, and you'll be able to see transactions coming in and going out.
Yeah, so to help you understand, as a regulated company, like, for example, if Alex Majinski used BnkToTheFuture, then we have to file suspicious activity reports to our compliance team, and then the compliance team would then file it to the Cayman Island Monetary Authority, and then the Cayman Island Monetary Authority would take that to the relevant regulator in the US. So every financial institution that is engaged in any of these transactions will, if they've got a robust compliance process, would have already filed those suspicious activity reports. And you've got, you in theory, we'll have some big players behind it. This should be DOJ level resources behind this. So, you're not going to get, plus you've got 600,000 disgruntled blockchain nutbags that are all going to be analyzing the shit out of every movement. So this is, if anything's going to get a lot of heat and attention, it's going to be the movements of all funds related to insiders.
Okay. All right. Sorry, I'm just having some technical difficulties on my end. Can I hold back on my second question for a second while I'm dealing with something on this end? Sorry.
Sure, Harry. You can stay up as long as you'd like.
Sorry. Yeah.
No worries. Victor. Victor, can you unmute yourself?
Yeah, hello? Yeah, I'm sorry about that. Thanks, Mary.
That's okay.
Yeah, so I have a question regarding, well, it's a two-part question. First part, in regards to the clawbacks, so the threshold from my understanding was anything, no clawbacks, anything under 100K, anything above 100K to 250 would be 27.5%. So that's one, just making sure to confirm. And then the second part would be, though either maybe David, Clancy, or Simon, maybe anyone have an idea when we're going to get a definitive answer in regards to when all this backlash or anything regarding clawbacks is going to get resolved. Because I feel like the longer it goes out, if people were to pay these clawbacks, I'd rather, even myself included, I'd rather pay them out sooner than later. I mean, everything's getting much more costly, and I'm more than likely to burn through that money just with necessities. So I'd rather pay them out sooner than later. Thank you.
I think it would be voted in with the plan, and so the final disclosure statement and vote and execution, we won't know the final outcome until actually executing the plan and people start to vote on which whether they're going to accept the convenience class, and then the Tony toggle is implemented. So I think this is going to be for the rest of this year at the very least.
I agree with that.
Yeah, it feels like there's going to be different places where people can decide to get off the train, so to speak. So basically, like this plan, there'll be a process of finalizing the plan and approving the plan.
Is anyone speaking?
Oh, sorry, Mary. I am. Maybe your connection. I think people can hear me.
Yeah.
I can hear Plan C. Mary, you can't.
Okay.
You might.
Yeah, Mary. Some of that seems to happen sometimes with the co-host in the space, but yeah, no, it's simply that there'll be an opportunity for people that want to get out, right? They say they're in that 100 to 250 range, potentially in the range between 250 and $1 million. There'll be an opportunity for people that just want to be done with it early in the timeline to take their settlement and be out. And that'll be voted on, and with the plan, it sounds like that'll be, at least as of now, that's what it looks like. So those people have the opportunity to say, you know what, I'm done. I don't want to be involved in this anymore. I'm going to put whatever dollar value back in to meet the settlement. I'm going to vote for the plan, and they can get off the train. But there will be, the timeline will be a lot longer for people that want to, maybe negotiate more or litigate. That timeline, it's really impossible to know. It'll be a lot longer though. So that's pretty much my answer.
I agree with that, and I'd just say that in the Tribune bankruptcy, it was fraudulent conveyance claims, but those claims basically went up and down from the district court to the circuit to the Supreme Court a couple of times. There were some lengthy delays in court, the district court issuing the decision. That litigation started in 2011 and ended in 2021.
and it never got beyond a motion to dismiss um, for 546E. So there were two real issues in that case: the safe harbor and a preemption argument, and it took 10 years for that litigation to resolve itself.
So I have to get off the space now because I have some other commitments, and I wanted to thank you for bringing me up. And I did want to kind of end on what I thought was at least the most optimistic thing that occurred in the hearing today, which was that it was revealed that there is potentially a competitor, doesn't have a binding offer or fully baked offering yet, but that is in discussions with the UCC and the debtor about a competitive plan. And that's good for us because in order to be a competitive plan that gets pivoted to, it has to be a better plan for creditors overall. So stay tuned. The plan may change. It may be Nova Wolf, it may be somebody else, but we're all getting closer by the day to exiting from this nightmare. Thank you.
Hey, I just wanted to, I know Plan C, you can't hear me, but hopefully everybody else can. I wanted to thank you, Yolo and Simon and David, Plan C, for putting this on, everybody that contributed. I got to go also, but I appreciate each and every one of you that contributed because I think when you ask the questions and the people that are answering, it helps everyone else out. But I have to go. Plan C is going to continue, and I appreciate you letting me be a part of everything. So peace to everyone. Stay positive.
Plan C, I need to run to. I have a 5 o'clock call that I'm supposed to jump on. So thank you again for the opportunity. I hope everyone does well, and I hope that we see some competitive bids. And the next time we're on a Twitter space, we'll be talking about different bids and a greater recovery. So on that note, I'm going to sign off as well. Thank you, everyone.
Yeah, thanks a lot, David. It's always great having you, and thanks, Mary, of course, as well. And yeah, no problem, guys. Appreciate your time. Thanks for joining.
Hey, Simon, I have a quick question regarding Silvergate. Now, do you think this is going to have an impact on Bitcoin's price, potentially maybe going sub 20K or maybe 19K?
Good question. Is it priced in? I think so. But we're about to see which exchanges had more than 250,000 exposure. They closed prior to this. They closed the Sen network, which is the network where exchanges can transfer funds to each other. Binance had already announced that they're suspending withdrawals in US dollar greater than 100K. That was a direct result. So how much did Binance have on Silvergate? How leveraged were they? They only had 5% capital last time I looked. So 5% capital is a hugely leveraged bank. And, I don't think they were prepared for well, actually, hold on. There was only $3.1 billion of deposits on Silvergate prior to that announcement. So the maximum exposure is the number of crypto companies that had over $250,000 and still couldn't get it off Silvergate. So I think there may be some additional things that may not be factored into the price. I don't want to do short-term speculation. I've never done that, but the reason I dollar cost average is because dollar cost averaging works best when markets are going down like this. So I always dollar cost average into Bitcoin, have been for a long time. So that's the best way to protect yourself in scenarios like this if you still believe in the long-term vision of Bitcoin.
Hey, Simon, related question. Oh, sorry, I'll let you finish.
Yeah, go for it.
Just related question, just your thoughts on this, and we'll go back to Celsius as long as people want to stick around. But with the Silvergate news, I mean, it's huge news, right? So, with a lot of the CeFi platforms going under, we eliminated some of the bad actors in the space, right? Like there was long-term, obviously a lot of pain and a lot of hardship from victims in the process, but it's like you had to eliminate some of this leverage in the system and bad actors in order to kind of get ready for the next cycle of crypto, right? You shake all this stuff out. But is this Silvergate, is this not necessarily shaking out more bad companies or more degens or more over leveraged or more bad actors? Is this actually shaking out reasonable players, or how would you assess the fallout? Like, is this a fallout that is long-term healthy, or is this a fallout that is not necessarily, you could classify that way?
No, this is not healthy. So it took us so long to get crypto-friendly banks in our industry, and this takes us back to where we begun. That has a two-tiered effect. It helps with Bitcoin adoption and people storing their own private keys and using Bitcoin the way it was originally intended to be used. But you have to have the on ramps and off ramps, and so it's a TradFi takeover essentially, because this bank was one of the only banks. Like, it took us so long to find banks that would service the exchanges. I mean, the only reason Binance is where Binance is because they managed to use Bitfinex as their bank through Tether, and that gave them like 2 to 3 years to figure out how to get a bank account. But it's been the Achilles heel in our industry for so long, and it's just really sad.
And when you're talking about these, like, this is specifically for the business sector of crypto, right? Like, because the individuals can get money in and out through their own banks or through various ways, but this is like big money. This is money that funds the projects in the space. Is that how you classify it?
Well, in order to have an exchange, you have to have a bank account, unless you're pure crypto to crypto, play. And so you either did it crypto to crypto with stable coins, and someone else like Tether took on the banking headache. And this is why the attacks on Tether were just so, because having been through the whole journey of Tether, from when it was a complete startup where nobody would use it, to I experienced the whole journey of understanding that all the issues with Tether were banking issues. And, I was there the day the Taiwanese bank shut it down, and then they had to go to another bank and then another bank. And they ended up with Crypto Capital, which is a shadow bank, just because they had to meet the sheer demands of trying to process those withdrawals. And they were essentially the whole backbone of all of these crypto to crypto exchanges and Binance and everybody. And so, yeah, if you this just really lays the foundation for a JP Morgan to launch their solution and then only bank themselves, because they've got a direct clearing bank, and so they'd only be comfortable with their own crypto financial services. So it really pushes things to TradFi. In terms of whether Silvergate was bad actors, I got a bit of conspiracy theory getting outside Celsius, where we talk about other things, which I can't wait till we can start doing that. But it looks like we're going to be talking about Celsius for the rest of the year, and then another 5 years, while we unwind everything. But there's such a, it's the timing of everything. So DOJ has suddenly decided to pick this moment to sell some of their Silk Road coins. Mt. Gox gets settled, and now that amount of Bitcoin comes onto the market. You have Bitfinex, which is probably going through the settlement at the same time as the hacked coins being found all these years later. So DOJ can hold those to try and get all those Bitcoins. DOJ is essentially the third largest holder of Bitcoin now, as a result of all this. And then you have this, all of this happening at the same time. It's just,
it does feel like it's everyone attack at the same time. Kind of, it's hard not to be conspiratorial when you see kind of the events that have taken place over last year and the start of this year. It does seem like the takeover attempt is in full swing, but yeah, we can try to make it positive. I mean, a lot of this stuff is going to make a lot of people give up on the space, but the space will recover, and it's just a period of time where all this stuff has to shake out, right?
Oh, I mean, we were the moment that the governments attack this aggressively, it means we're succeeding. This is not the time to quit if you believe in the battle. This is we've been at this for a long time, and if you were ignorant enough to just think that there wasn't going to be a large scale government attack, given that they didn't shut down Bitcoin in time when they had the opportunity to shut it down, and really sorry to get all Bitcoin maximalism in a Celsius bankruptcy, but this is why proof of work matters. If we didn't have proof of work, and this is the interesting opportunity that we really need to. Imagine if we did, I hear you with all these Chapter 7 and liquidations and planned liquidations, but imagine if we could restructure and end up with one of the largest proof of work operations as a result of this absolute mess, powering the most important part of the ecosystem. And the fact is, if we could end up with that, when we can just get beyond the initial pain and everything we're going through, it is quite an interesting opportunity, and it does take me to these emotions of highs and lows that we're all experiencing. But sometimes we need to see events like this and look at the bigger picture, that proof of work is really, really, really important for the future of the world. And if we have an opportunity to create some kind of reorganization around that, and we can just figure out how to achieve that together, that's way more important than just ending up another piece of TradFi. And I don't know exactly what that looks like. I'm going to cover more on Friday around competing bids and various other things. But it is an interesting opportunity that we find ourselves in. And when a bank that's been supporting our industry goes bust, it's just sad for the ecosystem. But I'm not sure everything's priced in. I'm not sure whether what we're going to see after this. But hopefully, many of the exchanges saw it coming. But the problem is I don't know. You can't move at the pace at which you need to, because sometimes it took us 3 years just to open a bank account in this industry. It's incredibly challenging. It's incredibly hard. And the only reason we got through it is because we operated as a securities business. And as a securities business, we were able to comply with regulations. But the crypto first businesses, we kind of shoehorned a crypto business into a Bitcoin business into a securities business. But most people started as Bitcoin businesses and then tried to figure out how to comply. And so, it does relate to what we're doing at Celsius, because we got to get through these securities regulations. We've got this massive proof of work operation, and there's something inside me saying we can figure out how to restructure that, even though there's such hurdles ahead.
How are you doing for time, Simon? Did you want to take a couple more? I mean, we've been going for a
let's
while,
go.
but
Let's go for it, man. But
try to get some of the last Celsius questions answered. So yeah, anyone has a question, just put your hand up, come up on stage, and we'll get some questions for Simon.
Can I go or no?
Yeah, go for it.
Okay, I had my hand up. I didn't know. Maybe you didn't see it. So thank you. I have a custody /OTC question. I had two
Tony
OTC
Toggle.
trades. What?
Question for Tony Toggle. He's up here.
Okay, yeah, that's actually why I came here. So because I heard he was a custody guy. So I did an OTC trade. Celsius. A lot of people probably already know this. For sell, and it went into earn. I did one later, a lot closer to the bankruptcy, and that one went straight to custody and never hit earn, and it stayed in custody. I got a custody email stating that I could withdraw, which I'm assuming it's because that was pure custody. I go to withdrawal. I did my whitelisting. I did KYC. I did all that, shebang, and it does not allow me to withdraw. I sent emails to Celsius. They gave me a bunch of weird answers, and they finally sent me and said, here's what they emailed. Thank you for the screenshots. We've provided them to our tech team, and they are looking into it. I will be in touch when there's an update regarding the issue you are experiencing. This came from a customer care and loan expert, which I've never touched loans in my life. I contacted Stretto. They were no help. And then 2 days ago, yesterday, I contacted Stretto, and they stated that they got an email from Celsius sent on 3/6 at 3:44 p.m. stating that custody has not been released yet. But yet I know plenty of people that have removed from custody. So do you know if there's ongoing issues with this?
I'm not really sure. I mean, a lot of people had technical issues. It revolved around updating your whitelisted address again after you do the KYC. Some people will get timed out. They had to do it kind of fast. Some people, they asked for a like a weird video, you have to write on a piece of paper that's your name, and this is how much you want to withdraw, and this is the address that you want to send it to, and then take a video of that paper with your face on it just to confirm that it's you. Did they ask
I
you to do
actually
that?
did a video as well. They asked me to do a video as well, and I did that. And like I said, after I've done all that, which was like 4 or 5 days ago, they have not responded to anything.
Yeah, so they said that turnaround's like 24 hours. So I would try to withdraw again. Just put another request, I guess. I'm not sure. I really don't have a good answer for that.
So just keep emailing these guys over and over again? Because Stretto essentially says that they can't do anything.
Well, Stretto has no involvement here. They're just managing the information from the bankruptcy. This is more of a Celsius matter. So I would just try it again. Just bother them until they figure it out. But they've said that everything has gone through within 24 hours. Like the latest would be the next day. And I've spoken to a bunch of people. They've had it go through. So I'm not sure. This is a weird one.
You should DM Tony every 20 minutes until it's done.
We had a guy in the custody Telegram group. This guy would message me every single day since they announced that they're going to release the pure custody. He would message me every single day, when is it going to get released? And I kept telling him what they told me. It's going to be in a week, in 2 weeks, whatever. They're working on it. They're trying to figure out the details. And then finally the day it was effective, like 2 days later, I messaged him like, hey, you haven't messaged me. It's up and running. You can withdraw. And he's like, yeah, I got to do my KYC. Like 2 days later, I'm like, dude, you've been harassing me and you didn't finish your KYC?
Yeah, and if anyone needs their Flare token, you just got to DM Tony.
Yes, I have all the Flare.
So I actually have a new ticket in. Like, I just keep on making tickets. And this last one is at 25 hours. So it's past the 24-hour mark.
Does it let you try to withdraw again, or does it say you maxed it out?
It says, well, I can do it right now. But it says that, I have, let's say, 10,000 cell available to withdraw, and then it only allows a max of like 9,000 or whatever, right? So you hit the max, I click that, and then it says you do not have 9,000 worth of cell. The max allowed is 9,000. So it says the exact amount that I put. So I even put only 100, like a small amount, and it gives the same exact message. You cannot withdraw 100. The max you're allowed is 100.
Are you out of the country currently by any chance?
No, I am in Illinois.
Are you withdrawing to an exchange?
MetaMask.
Okay.
Yeah, this just sounds like a tech issue. So I think the only people that can solve it is Celsius.
Yeah, that's. I really don't have a good answer, honestly. It sounds like they're just messing up on their end.
So I just got to wait until sell goes to 0 and then get my money?
Well, sell is always going to be worth one sell, so you should be good. But yeah, I would just call them and email them, just harass them.
Do they
See
have
how
a number?
this pure custody getting to front run the sale token? Jesus, man.
Well, exactly. I'm trying to front run and I can't.
Well, pure custody is going to front run it, and then transferred custody is going to get a second go at it, and then by the time everything's released, it's probably going to be as close to 0 as we're going to get.
By the way, Simon, I know that you were joking about Flare token, and I can give a shit about it, but it disappeared from my app. So anyone who was expecting Flare token in Celsius, check your account because it's completely disappeared from mine. Not that I give a shit.
Eric is a Flare token.
I'm a Flare maxi. You're right. I mean, but it does seem a little bit. I mean, it's probably the least shadiest thing that's happened during this whole process, but it does seem a little shady that it was there and like literally Flare doesn't even. It's not even like there at all. Like Flare's not there, the amount's not there. It's just removed from the app. So someone at
heads up.
Someone at Celsius is working. You know.
And just a reminder that none of it was ever there.
Right. Well, yeah. Good point. But it's really it's not even like a.
What about your ETH proof of work? Is that the?
Well, yeah, my ETH is there. Yeah.
Yeah. Well, in court today, if anyone heard Chris Ferraro was saying that they have 24-hour ticket time, so hopefully they'll get round. They said they had 1,700 tickets, so maybe there's a bit of a backlog.
Yeah, it turns out not everyone withdrew from pure custody. Like, I don't know what these guys are waiting for.
Well, I'm not
hodl mode. They're in hodl mode.
Yeah. Well, I know DeFi Ken is trying, but the other people that aren't even trying, what are they waiting for?
Anyone else on stage have any questions or anyone in the crowd? If you guys want to come up, feel free to ask any questions. Join the conversation.
Hey, Simon, if they were to go away from this equity token, it'll be pretty easy, right? You're just giving out paper equity. I just don't understand the necessity of equity tokens.
There is no necessity. It's just a way of getting adoption for the Provenance blockchain. That's it. So we at Bank to the Future we did everything centralized because the reason for it is because when we were speaking with FINRA and the SEC around tokenizing, they said to us that in the case that anyone's security token gets hacked, you have to revert back to the centralized database anyway. So you need to keep a spreadsheet backup of everything, and so the whole point we could get. So when we did our secondary market, we just had, 0 gas fees, 0 confirmation times because we just used a MySQL database. So yeah, it's just a way of getting adoption for the Provenance blockchain, and the fact that White and Case were involved in switching the hash 1.0 from a security token to hash 2.0 utility token implies that this is aspirations of creating another flywheel.
Just let them hash it all out.
Exactly, and you can grow new hash tokens.
Yeah, I mean, this has all the makings of another Celsius 2.0. It's just a cell token, just with a different name. I mean,
yeah, but I don't want to shit on it too much. This is public reporting company. It will be regulated under SEC. A lot of scrutiny around that, but yeah, the provenance blockchain part of it and the security token part of it is the bit that that I think will get them probably quite a lot of pushback in us getting out of this plan.
because it doesn't seem like Figure really wants the loan book, right? Because they don't really do retail loans. So it seems like they just kind of throwing that in there just to give them something to do.
Well, they're giving the loans to Nuco, aren't they? There are that's our reorg.
Yeah, but Figure is basically the one with the, I guess, the lending license.
Yes, correct. Yeah.
I don't know. Doesn't make sense. You're just adding blockchain to something that doesn't need a blockchain, basically.
Well, that's what bankers do. They originally tried to co-opt Bitcoin and use the word blockchain. That was their 2014 strategy. And ever since then, they've been trying to shoehorn blockchain into financial services. And yeah, this is another attempt.
Well, that's all Cagney has said. I mean, I've seen the one video, and then when he came on the Spaces, it's just blockchain, blockchain, blockchain. But it doesn't need to be on the blockchain. You know, like I don't need a picture on the blockchain. I could just hold the picture. You don't need to put my equity on the blockchain. I could just hold the equity.
Yeah.
All right, well, this
Are
died.
we running out of steam then, Plan C, or is there anyone got any more questions?
Yeah, anyone? Yeah, we can do a couple more if there's people. I don't know. It seems like everyone doesn't have any questions all of a sudden. But yeah, we'll keep going if there are a couple more questions. But yeah, if you have to jump, Simon, we've been going for quite a while, so no problem.
Oh, also, I've been promoted to the loans ad hoc secretary. I guess they've had a bunch of issues getting new ad hoc members. I guess signed on. So if anyone's looking to join the loans ad hoc, I'm the new secretary apparently. So just send me your info.
You're all over the place, Tony. You're involved in all the ad
Tony's like,
hocs.
he's single-handedly holding up the whole of Celsius customer support.
I'm
He's
just
got
toggling all over the place. Hey, you want to bring up Ronan?
What's that?
I think Ronan's here. You want to bring him up?
Oh, I don't see any requests. Let me let me add you as a co-host, Tony, and then you can. Because sometimes I don't see the request. Here, I'll invite you to co-host.
Oh, Ronan's been dying. He's been given Zendesk access, so he can answer Celsius tickets direct.
Go ahead, Joey.
Hey guys, yeah, Simon. Just a moment ago, you mentioned that there'll be a regulated, potentially publicly traded company, Nova Wolf, and
not publicly traded, public reporting company. So it just
public
means they
reporting.
have to meet the requirements to transparently publish all their finances for the new co every quarter and file them to the SEC.
I've got it. Okay, understood. And Simon, my heart's racing a little bit today, just because Coinbase, being a public reporting, publicly traded company, I just had a $106,000 hack this week on Coinbase, and this is following the $110,000 loss on Celsius. And Coinbase's customer support, 10 days, I still can't get into my account, and they're telling me that I owe them $100,000 after this hack, because the hackers were able to access my bank accounts through their connected to the Coinbase platform. So now I have to go to court for that, and I just filed a police report today. So I'm wondering, Nova Wolf being new to the market, standing up security protocols, if Coinbase can still get hacked at this point, are we looking at connecting our bank accounts to Nova Wolf or transferring in our crypto? And at this point, my paranoia leads me to believe, why don't I just create my own hacker group?
Yeah, it's a big concern. Firstly, I'm sorry to hear about that. But that's a big concern, because we in order to run a securities business that can handle that many investors, we've had 10 years worth of coding, and every type of thing that can happen does happen. But this is when I signed up for Figure, yeah, it's really early tech. So I think it's really important to have a competing bid from battle-tested technology and platforms that understand Bitcoin a bit more than blockchain. But sorry to hear about the hack. What was the issue? Was it something because they managed to? Did you say it was at the bank level? They managed to get the bank details.
Hey Joey, you got unmute. I muted you just because of the background noise. Oh, are you there, Joey? It was Joey, right?
It was Joey, yeah. While he's sorting that out, Ronan's up here.
Them again.
Tony, yes, Tony. The rumors are true. Tony is the official loans ad hoc intake secretary / administrative assistant. We are a small crew. David only bills me now for Twitter Spaces hours, so we are going to be expanding the ad hoc to facilitate the payment of Twitter Spaces. But I appreciate Tony hopping on and doing that. I was not able to attend the hearing, so I'm flying blind. But Simon and others, I appreciate you guys live tweeting and providing your commentary. It's good. My understanding is that this was the Frischberg hearing, and then they're gonna hopefully pick the official stalking horse at the next hearing. Am I tracking that correctly? And maybe hopefully it'll be I'm going to put the word out now. I'm going to contact Silvergate Bank and see if we can get them to be the stalking horse bidder.
Sorry, guys. I'm going to be on Real Vision in 20 minutes to discuss Silvergate, if anyone's interested in that topic.
Simon, why are you going on RuPaul's Real Vision? Are you going to call him a peak scammer because he basically called Terra Luna risk-free returns?
Oh, what's Raoul Pal?
Raoul Pal is what he is. He's up there with BitBoy, some of these others that just rug pull after rug pull.
Yeah, Raoul Pal went nuts in the bull market. He
Rug Powell. That guy basically, Terra Luna basically risk-free. Never forget.
It's funny because he actually got me to understand Bitcoin a little bit better before he lost his mind.
Raoul is serious. Yeah, he's got serious content, but he tapped out of Bitcoin during Bitcoin Cash. Then came back, and I mean he's smart as hell. He's got some serious content, but then he went absolutely nuts in the bull market. Yeah,
as we all do at times. What's his Real Vision membership subscription? Is it $3,000 a year?
Oh, I don't know. There's so much free content. I've never looked at what the business model is.
All right. Well, I do appreciate
$1 trialing.
Will you at least ask if he'll accept all these people getting their cell token released? Maybe they do some type of promo deal. # use promo code Tony. Maybe they do a cell token Real Vision membership subscription.
Yeah.
Yeah, you get a free month for every time you get rug pulled by Raoul's pump and dumps.
Hey Tone, you're now the co-host, right? So Tone gets roped in for customer service for everybody. Plan C's like I even had Tone, I went out to dinner, left Tone in charge of my space, and he was managing all the tickets for Celsius, managing all of the customer service for each of the ad hocs, and also managing co-hosting a Plan C spaces.
He's got his claws in every single ad hoc group. He's actually not only additionally the co-chair of the official cell ad hoc, but he is starting up I think he's going to be the sole chair of the ad hoc, which is going to bring together all ad hocs, including the new Silvergate ad hoc that is seeking to be the stalking horse bidder in the Celsius bankruptcy. So, yeah. And
I've got a theory as well. I think he's the insider that leaked to Tiffany.
And the other thing is, I got an email for having a little bit of Solana. Tony emailed me. He's getting together the Solana maxis who are going to be advocating for petition price repayment, because Solana maxis will be making out like bandits because of that is the only token, due to its sheer complete total worthlessness, that a lot of scamfluencers shield, that those Solana maxis will benefit being in bankruptcy with petition prices. You love to see
He was
it.
also the chief blockchain analyst alongside CryptoSexual, investigating the 289 bitcoins as well.
Simon,
He cracked the case.
Simon, right now,
You got your bitcoins back.
I don't want to be the one to say it, but I'm going to. For as official spokesman for the CryptoSexual ad hoc, you owe CryptoSexual a portion of that returned Bitcoin. I think we can. You don't owe him all 289 of it. He did crack the case, looking out for your best interests, but I think you do in fact owe him a portion to fund the discount fake 81-cent ad hoc.
I'll give him a cut if he joins and becomes, like, top recruiter for the Church of Scientology he's in.
Yeah, it's kind of crazy how that all played out, eh? Like, he basically was desperately trying to find any dirt on Simon, and it led to a recovery of Bitcoin for Simon.
No one is more obsessed with Simon than CryptoSexual. It's shocking. It's almost impressive, but he dove so deep into Simon's financial affairs that he was able to recover him 289 Bitcoin. Simon, when you get that recovery, you have to think and thank old CryptoSexual for that.
I'm going to create a new ordinal connected on SegWit to those 289 bitcoins, and it's going to be 289 JPEGs of all of the last pictures from the last 8 months, one for every Bitcoin.
See, everyone thinks that picture I posted is just a very poor Photoshop job, but it's actually real. He took a picture of his closet, and that's what it was.
Hey guys, I think we should wrap it up, because someone's got to run, and I'm kind of running out of steam here too. But
definitely gone downhill. It's definitely gone downhill. As soon as raining came on, it's time to stop.
Well, we've been going for a while. I mean, but guys, I think most people got the questions answered.
This has gotten pretty pathetic. I got to be honest. This is all downhill from here.
Well, this one guy, Joe Pimpy, it won't let me approve him to come on stage.
Sometimes Twitter Spaces, it's tough to bring people up. Sometimes there's glitches. But anyways, thanks for joining, guys. I think it was mostly a good discussion. We went for at least a few hours now. So we'll be doing more of these, of course, after every hearing. And I guess thanks for joining, everyone, and Simon. Thanks for answering all these questions, and we'll see the fallout with Silvergate. That's kind of the news outside of Celsius. There is a world outside of Celsius, believe it or not. But have a good one. Have a good night, everyone. Anyone else want to say anything? Go for it.
Congrats to Withhold, right? I mean, I guess they came to some sort of settlement. I mean, I always felt, and I believe that Cussy always felt like they were similarly situated to us in custody. I don't have an idea of what their settlement is. Tony, you have any idea? Regardless, congrats to them.
I do, but I don't want to say it because what you said was very nice. What I would have to say is not very nice.
Okay.
Withhold. It's a massive issue in the overall Celsius bankruptcy. Let me check my financial figures. $15 million. Shout out to those probably like 6 Withhold users. I'm glad they're getting hopefully the majority of their funds back. We really got to deal with the crucial issues of this case, and that is Withhold.
So basically, if Frischberg never filed a motion, we could have just paid Withhold in full, and nobody would have felt it.
Yeah, well, I hope it works out for them, regardless. But okay, guys, I'm gonna wrap it up. Have a good one. Take care, everyone. Any parting words, anyone, before we close?
Contact Tony V to join the official Cell ad hoc. He is the point to join that group.
Yes, we need new members to pay for all the old members.
All right, later, guys. Take care.
Bye all.